meeting of the Wilsonville City Council under special meeting. And I would like to ask if everyone could please turn off their cell phones and note that to allow us to listen and hear everyone, we ask that everyone in attendance maintain decorum and quiet so that we can all hear the speakers. Thank you. I'm going to start off by reading our City Council mission statement, which is something we've started doing, which is to protect and enhance Wilsonville's livability by providing quality service to ensure a safe, attractive, economically vital community while preserving our natural environment and heritage. And we're going to ask for an approval of the agenda as presented, but I just wanted to say a couple words about this particular meeting. And the following is a summary of the legislative and other matters on this agenda to come before Wilsonville City Council, a special session to be held May 17th, 2024 at City Hall. Legislative matters must have been filed at the office of the City Recorder by 10 a.m. on May 8th, 2024. Remonstrances and other documents pertaining to any matters listed in said summary filed at or prior to the time of the meeting may be considered there and except where a time limit for filing has been fixed. So this is a special set council meeting to consider an appeal from a decision by the Development Review Board, which is not a public hearing. No other city business will be conducted at this meeting. I just want to let people know that's why you see such an abbreviated agenda. Do you have anything to add to that, City Attorney Guile Hinman?
Thank you, Mayor. This is really based on the order of appeal that the City Council adopted at its May 6th to 2024 meeting, where it designated the procedure for this meeting today, which is that it is an appeal on the record before the DRB, so there's no new testimony or evidence that's being provided, and it is between the appellant and the city staff.
Thank you. Will the City Recorder please call the roll?
Councilor Berry? Here. Councilor Linville?
Here.
Council President Ockervall?
Here.
Councilor Dunwell? Here. Mayor Fitzgerald?
Here. Will everyone please join me and stand for the Pledge of Allegiance? I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Do I have a motion to approve the following order of agenda?
Your Honor, I move to approve the following order of agenda.
Is there a second?
I second.
It's been moved by Council President Ockervall and seconded by Councilor Dunwell. All in favor say aye.
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 Motion passes 5-0. That brings us to new business. And I will call to order at 12:04 p.m. on May 17th, 2024, the Wilsonville City Council appeal proceeding regarding the appeal filed by Lars Anderson and Associates, Inc., concerning the Development Review Board's resolution number 432, case file DB24-0003. I want to first ask if any members of the City Council wish to abstain, declare a conflict of interest, or report any ex parte contact outside of the meeting. And I'll start by saying, for my part, I know that, we all have heard that there is, discussion about this in the community, and some people have come up and brought it up to us. And for my part, I have not engaged in those discussions, and I have referred people to the council packets for the DRB and the City Council. And so I do not have any ex parte communication to report. So again, do any members of the City Council wish to abstain, declare a conflict of interest, or report any ex parte contact outside of the meeting?
No. No.
Nope. No. Okay. And secondly, have all members familiarize themselves with the record?
Yes.
Yes. Yes. Does any member of the audience wish to challenge the participation of any member of the City Council? Okay. I'm not seeing any. This proceeding is an appeal of the Development Review Board's decision concerning confirmation of an existing non-conforming use occurring on 29400 Southwest Town Center Loop West, Wilsonville, Oregon, 97070. As such, this appeal proceeding is being held on the record only, meaning no new testimony or evidence of any kind is being accepted, neither in person nor in writing. The City Council, thank you. The City Council will only consider the evidence already on the record that was before the Development Review Board when it made its decision, and again, no evidence will be taken or considered. Although City Council meetings are open to the public may also attend remotely in accordance with Oregon law. Information regarding how the public can attend this proceeding remotely is posted at City Hall and on the city's website. The protocol for today's meeting will be as follows. City staff will present a summary of the DRB process and the DRB decision, as well as what staff recommended to the DRB. Staff will also advise City Council as to what portion of the decision the appellant is challenging, what the applicable city code sections are, and a summary of staff's interpretation of each section as presented to the DRB. If the council has clarifying questions for the staff, they may be asked or held until after the presentation. The applicant will then be asked to address City Council concerning the appellant's challenges to the decision. The appellant may also address any statement made by staff that appellant believes is not correct. The appellant's case must be based on evidence in the record. No new evidence shall be presented or argued. After the appellant finishes its argument, I will ask the City Council if any members have questions for the appellant, and those questions will be asked and answered. After the questions of appellant are asked and answered, city staff will be given an opportunity to present argument. Again, staff argument shall only rely on evidence in the record. At the end of the staff argument, I will ask City Council if any members have questions for staff, and those questions will be asked and answered. Appellant will then have the opportunity to provide a rebuttal, which will be limited to 5 minutes. After appellant finishes its rebuttal, I will ask the City Council if any council members have questions for the appellant, and those questions will be asked and answered. I will then ask the council members if any of them have additional questions for the appellant or city staff. Once all questions have been asked and answered, the council will then deliberate on the appeal. So I think we will now begin with the staff report.
Good afternoon, Mayor Fitzgerald and councilors. My name is Cindy Luxhoy, Associate Planner, and I am here to present a factual report related to the appeal of Development Review Board Resolution Number 432, case file number DB24-0003, as required under Wilsonville Code 4.022.06A1. Assistant City Attorney Stephanie Davidson, to my right, also will be speaking later in this presentation. The property subject to the appeal, referred to as the location, is at 29400 Southwest Town Center Loop West, outlined in red in the aerial photograph on the left of this slide. The existing development at the location is shown in the photograph on the right. The comprehensive plan designation of the location is Town Center, and it is zoned Town Center, or TC. To provide some procedural background, on October 30th, 2023, the city received an application for a Class 1 administrative review, case file number ADMN 23-0029, to confirm the status of the existing use and structure at the location. But in the same application, the appellant also asked the city to confirm that the Home Depot and Fry's Electronics are both warehouse retail uses and that the Home Depot may operate in the existing structure. The second request for a continuation of use determination required interpretation of WC 4.189, which is processed as a Class 2 administrative review per WC 4.030.01B3. On November 28, 2023, city staff contacted the appellant by email explaining this clarification and providing options for processing the application, but received no response within the time period. As outlined in the code, a Class 1 administrative review is intended for minor decisions and modifications. It is processed as a ministerial action against objective criteria, and as such does not require public notice or a public hearing, only providing the applicant appeal rights. Confirmation of existing nonconforming use as opposed to a determination of continuation of use or change of use is a Class 1 review, pursuant to WC 4.030.01A7, which states that a Class 1 application is required for a determination that an existing use or structure is a nonconforming use or nonconforming structure, as defined in the code. Comparatively, a Class 2 administrative review is a more substantial change and/or requires professional judgment in applying the relevant code criteria, and thereby requires public notice and is subject to appeal or call-up. Evaluating a proposed use as it compares to an existing recognized nonconforming use requires professional judgment, a comparative analysis, and an interpretation of information and code, and thereby should also allow the right for public review and appeal. Interpreting the nonconforming code provisions in WC 4.189 through 4.192 as applied to the location is a Class 2 review pursuant to WC 4.030.01B3 and can be called up pursuant to WC 4.030.1B. On December 15, 2023, the city received an application for Class 2 review, which was assigned case file number AR23-0031. The request was stated as a Class 2 staff interpretation to confirm that the Home Depot and Fry's Electronics are both warehouse retail uses. Further, the appellant described the application as an application for a staff interpretation of the Wilsonville Development Code to confirm that the Home Depot store proposed for 29400 Town Center Loop West, Wilsonville, Oregon, 97070, constitutes a warehouse retail use and may operate in the existing structure. The city deemed the Class 2 review application complete on January 12, 2024, and processed the request as a Class 2 Planning Director interpretation per WC 4.030.01B3. Per Wilsonville Code 4.030.01A7, determination of the nonconforming status of an existing use was processed through the Class 1 process. The subject of the Class 2 administrative review was to confirm or deny the proposed occupants, the Home Depot, proposed use of the location constitutes a continuation of the nonconforming use currently located at the location referred to as the current occupant. Given the public interest and comment on the Class 1 review application, the planning director, in anticipation that persons other than the applicant were expected to question the application's compliance, referred the application to the Development Review Board for a public hearing pursuant to 4.035.03B as case file number DB24-0003 under the authority set forth in WC 4.030.01B. The public hearing occurred on April 8, 2024, and the written record was left open until April 15, 2024, for the appellant to submit additional evidence. On April 24th, 2024, the Development Review Board reconvened to consider the application, and by resolution number 432, denied the proposed occupant, the Home Depot. Proposed use of the location is a continuation of the existing nonconforming use. On May 7th, 2024, the appellant filed a notice of appeal of the Development Review Board decision in resolution number 432. An appeal of a Development Review Board decision is heard by the council per WC 4.022.02. In anticipation of an appeal, on May 6, 2024, the council adopted an order to conduct a special meeting on May 17, 2024, to address the matter. Pursuant to its authority under WC 4.022.05A, the council limited the appeal to a review on the record, subject to WC 4.022.06, and will not hold a public hearing or otherwise accept any additional evidence. The key issue highlighted in the appellant's notice of appeal is the following. The decision's determination that the appellant's proposed Home Depot development does not constitute a continuation of the nonconforming use at the subject property, which is that of a commercial retail operation or retail store. Thus, the primary question before council in today's proceeding, as shown on this slide, is the following. Does the council agree with the Development Review Board determination in resolution number 432, denying the proposed occupants, the Home Depot, proposed use of the location is a continuation of use? Assistant City Attorney Stephanie Davidson will now present about the legal standard applicable to the appeal.
Mayor and City Council, my name is Stephanie Davidson. I'm the Assistant City Attorney. Can I borrow the mouse?
Yes.
Thanks. This slide will look familiar to you. The same standard that applied in the Class 1 proceeding applies in this Class 2 proceeding. So first, it's important that the appellant has the burden of proof in this matter. In other words, has the burden to prove that there is a continuation of use. This is clearly established in a few cases that are cited in the staff report. So now we are on page 6 of the staff report, if you're following along. Hold on. Excuse me. This is established in the case ODOT v. City of Mosier and Sabin v. Clackamas County. If this decision is appealed to LUBA, it is important to note that the substantial evidence standard will apply. This standard is in ORS 197.835 sub 9. This statute says that LUBA shall reverse or remand your decision if it is not supported by substantial evidence in the whole record. Under this standard, it is not enough for LUBA to say that a reasonable person could come to a different conclusion when reviewing the evidence in the record. It requires more than that. The case River City Disposal v. City of Portland, which is a LUBA case, is really helpful in understanding how the burden of proof and the substantial evidence standards interact with each other. Those first 3 subpoints up there are from that case. The River City Disposal case is helpful because it was also a case about non-conforming uses, and it went to LUBA, and the substantial evidence standard also applied. That's why it's helpful. So first, the city may decide the evidence is not persuasive or credible. That's part of your job today. The city is not obligated to present its own evidence due to the burden of proof standard applying. And finally, it's possible for the city to say that the appellant has failed to satisfy its burden of proof, again, without the city, proposing contrary evidence. Next, I want to highlight the part of our code that deals with continuation of non-conforming uses. This is WC 4.189, I believe, subpart 1, and that's verbatim the language of that section. There are a couple of additional subparts. One relates to manufactured and mobile homes. That does not apply. And the final subpart relates to conditional uses, which also does not apply. So this is really the only part of our code that is helpful guidance. Because I mentioned this during the Class 1 proceeding, non-conforming uses are a right that's sort of been created and fleshed out by the courts over time. So we don't only look at our code, we also have to consider Oregon case law on the matter. I'm just going to go over what is a non-conforming use in case it's helpful to anybody here today. Essentially, and we're on page 7 of the staff report now. A non-conforming use is a use that is contrary to a land use ordinance, but that nonetheless is allowed to continue because it existed prior to the enactment of the ordinance. That definition really comes from the Morgan case, which is cited in the staff report. And I don't have a slide for this, but I do quickly want to go over some content that we have on page 7 of the staff report as well. There are a couple of cases that are instructive and really helpful. Parks v. Board of County Commissioners of Tillamook County. In this case, the Court of Appeals said, provisions for the continuation of nonconforming uses are strictly construed against the continuation of the use, and conversely, provisions for limiting nonconforming uses are liberally construed to prevent the continuation or expansion of nonconforming uses as much as possible. So that's sort of, the approach that we must take today in this continuation of use case. The other case is Clackamas County v. Gay, which is a Court of Appeals case. This case is quoted for the proposition that the law of nonconforming uses is based on the concept, logical or not, that uses which contravene zoning requirements may be continued only to the extent of the least intensive variations, both in scope and location, that pre-existed and have been continued after the adoption of the restrictions. All right, so now we're on pages 8 through 9 of the staff report. I want to quickly go over the framework for this decision in very general terms. There are a number of cases that I'll go over in a moment that deal with either continuation of nonconforming use or a change of nonconforming use. What we see in these cases is an evaluation of the activity that a property owner or a user is seeking to protect. It's either going to be a continuation, so it's going to be the same as the pre-existing activity, or it's going to be different, in which case it's a change. So activity is going to fall into one of those two categories. And I provide this quote here. It's also on page 8 of the staff report, I believe. This is also from the River City disposal and recycling case, which I talked about when I discussed the burden of proof. In this case, the court said, we believe a change in use includes adding a new use to an existing non-conforming use. So that kind of goes to the framework that I was just going over with you. And again, just as in the class 1, the reference point, the thing that matters the most is the nature and the extent of the actual use at the time the use became non-conforming. There's no dispute or controversy in this case. Both parties agree. The relevant date is June 5th, 2019, because that is the date that the town center zone became effective. And the foundation for your decision today is City Council Order on Appeal of DRB Resolution Number 429, which is the decision you made in the Class 1 review. That case is currently on appeal to LUBA, so it's possible it'll be remanded or reversed or overturned in some way. But as of today, that is the city's decision in terms of the nature and extent of the non-conforming use at this location. And it's the starting point for today's decision. I think my mouse is stuck.
There you go.
Okay, there we go. So there's less case law that I'll present to you today compared to in the Class 1. I do want to talk about these cases quickly. We've cited the Larson case to illustrate the process that the city should use to evaluate whether activity is beyond the scope of the non-conforming use. In this case, there was a 1991 administrative decision that protected that recognized use that you see on the screen for storing and repairing marine construction equipment and a base of operations for the property owner's construction company. This is an interesting case because it went to the courts again because neighbors complained that, they were bothered by the activity that was at this property. So what happened is the courts looked at certain types of evidence. They looked at testimony that log trucking began in 1993, the fact that the petitioner advertised for truck drivers, and the fact that they obtained a state license that allowed the hauling of trucks. And what happened is they said that, log trucking is clearly beyond the scope of what had been recognized as a non-conforming use in 1991. The second case is Fraley v. Deschutes County. These are both LUBA cases. Let me just double check that. Yeah, they're both LUBA cases. So this is perhaps a helpful comparison. I do want to point out, we agree with the applicant in this case. They noted in their briefing that this case is based on a statute, ORS 215.130. We agree that is a statute that only applies to counties and not to cities. We have cited this case because it's a helpful illustration of how a local government makes this comparison of uses, even if that statute does not apply in this case. So in that case, the county found that the prior owner Oh, and sorry, the other reason that I think this is really helpful is the initial recognized nonconforming use that was recognized when the property was owned by one person. And this case is kind of similar to what we're dealing with here because the property at some point was sold. So the party that was actually seeking recognition of the expanded use was a different person. So it's kind of similar to what we're dealing with in that respect. But the initial recognized nonconforming use was for the structural repair of motorhomes, campers, RVs, and camp trailers. And what the court said is that not all repair is equivalent and not all industrial manufacturing activities are equivalent. What they found is that the new property owner was engaging in the repair of diesel engines and tractor trailer trucks. So, repair of engine parts, and they drew a distinction between, even though some might say that these things are similar, the court said that repairing motorhomes, campers, RVs, and trailers is not the same as repairing diesel engines. And there was some discussion in that case, too, about exactly what type of product was being stored in the yard. In one case, it was lumber. In the other case, it was various truck parts.
Need me to advance?
Yeah, go ahead. Finally, I actually think the Hengen case is probably the most important case in this Class 2 proceeding. This case we talked about a little bit in the Class 1 proceeding. There is some disagreement between city staff and the applicant in terms of, what it says and doesn't say. But I do want to highlight it because it gives an example of it shows that the emphasis should be on an examination of actual uses, actual activities. It doesn't. This is not about the identity of the person who's engaging in those uses. It's about what uses are protectable and what uses are not. So in this case, the recognized use was for the storage of commercial goods into specific structures on the property, and they discussed storage specifically for cedar wood fencing materials. This property owner was also trying to seek, recognition of a non-conforming use for an office facility for the same business, but because the hearings officer at Clackamas County, they looked at the evidence, they said there's no evidence that there was an office facility on this property at the relevant time, and so that specific use was disallowed, whereas the storage use was allowed. And finally, I'm still going to speak a little bit about the Hengen case, but in my mind, this Venn diagram is really helpful for understanding what the Hengen case says and doesn't say. Sorry, excuse me. So, one of the key disagreements between city staff and the applicant in this case is, do you focus on commonalities? So do you focus on that shaded oval in the middle, or do you focus on differences? There is language in this case that refers to common nucleus. City staff do not think that there is a definitive common nucleus test. In other words, we do not read this case to say there's a common nucleus, so therefore, everything in that Home Depot circle can go into this location. There is language in that case that says, it provides helpful guidance as the city makes this decision and compares, Fry's Electronics use of the location in 2019 to Home Depot's proposed use. The court in the Hengen case did say that storage by itself could be a recognized non-conforming use regardless of whether, you're storing stuff that relates to on-premise businesses or off-premises businesses, but it said local government must make that determination considering factors such as the different impact of those two uses being compared. For example, if you're talking about storage of materials that originated off-site, is there an additional impact from the trucks or the transportation that brings those goods onto the property that merits not deeming that storage use as one and the same? And in the city staff's reading of the Hengen case, we believe that the correct analysis is first to define the nonconforming use, which was done in the Class 1 proceeding, and then evaluate whether Home Depot's use is the same as Fry's Electronics use. And finally, I would say that, even if there are commonalities, so even if there are some products that Fry's Electronics and the Home Depot both sell, this graphic does not give a comprehensive list of what we believe those commonalities or differences are. They are just examples. So a couple of examples that stand out to me are chairs and ancillary sales. I would say ancillary sales are things like what you see at a check stand, chapstick, candy, things like that. In our reading of the Hengen case, based on that language I just highlighted, has there been a fundamental change in the nature of the use? The fact that there are commonalities, that does not compel the city to recognize the applicant's requested relief, which is recognizing a non-conforming use for commercial retail use and allowing all of those other activities in the Home Depot circle to be allowed as a continuation of use. So I do think the Hengen case is really important here, and I want you to keep this Venn diagram in your mind as Cindy goes over the next few slides.
Thank you, Stephanie. In responding to the key issue on appeal, does the council agree with the Development Review Board determination in resolution number 432? The first question to address is, what is the current non-conforming use? As determined by the Development Review Board decision in the Class 1 review application, in case file number DB24-0002, resolution number 429, and affirmed by council in its order on appeal, there is a legally established non-conforming use at the location. Specifically, that the protected use is a 159,000 square foot electronics-related retail store, referred to as the current applicant. When the TC zone regulations went into effect on June 5th, 2019, the occupant of the location was Fry's Electronics. The appellant's application characterized the current occupant as follows. Fry's was a large electronics warehouse store that retailed software, consumer electronics, household appliances, cosmetics, tools, toys, accessories, magazines, technical books, snack foods, electronic components, and computer hardware. Fry's also had an in-store computer repair and custom computer building services and offered technical support to customers. As demonstrated in the as-built floor plan, photographs, and discussion in the Development Review Board decision in the Class 2 review application in case file number DB24-0003, items available for sale at the location by the current occupant were consistent with an electronics-related retail use, including computers, monitors, and small electronics, and related accessories. The majority of products were sold small in size. The majority of products sold were small in size and could be carried in hand by the customer. No activities occurred outside of the structure at the location, including storage, staging of inventory, or receiving, unloading of heavy equipment. In 2019, at the time the TC zone regulations went into effect, the store was operating in the same manner as what is shown in the 2014 floor plan. Based on this information, the Development Review Board concluded that the current occupant sold the following: electronic components, computer accessories, computer hardware, computer software, office goods, telecom equipment, video accessories, audio equipment, televisions, small appliances, CDs, videos, and video games. The second question to be addressed is, what is the proposed use? The appellant's application characterized the proposed occupant at the location as follows: Home Depot operates home improvement warehouse stores that retail tools, construction products, appliances, and services, including transportation and equipment rentals. Home Depot's Home Services Division also offers technical expertise for home improvement projects and both on-site and off-site install, repair, and remodel services. Further, the appellant, in its characterization of the proposed occupant during its presentation at the Development Review Board public hearing on April 24, 2024, showed images of a typical Home Depot interior. Merchandise included such items as floor polishers, tools, and hardware, chainsaws and saw blades, flooring, paint, windows and doors, large appliances such as washers, dryers, and refrigerators, and light fixtures and lighting systems. Much of it displayed on floor-to-ceiling racking, requiring an industrial step stool to reach high display levels, and all typical of a home improvement warehouse. The appellant states that no exterior garden center is planned, although the site plan includes an interior garden center. The appellant further states that the lumber pad is an operational area for safe receiving, unloading of heavier merchandise, not for exterior storage. It's expected that receiving and unloading would occur outside prior to moving the inventory inside for storage. During its presentation to the Development Review Board, the appellant described the staging of large product and delivery to the store by large trucks, including flatbed trucks, when product that is so large it is not in a box truck or a 53-foot trailer that could back into a loading dock. Other statements by the appellant describing the differences between the current occupant and the proposed occupant are documented in the council staff report and attachments. Finally, in responding to the issue on appeal, the third question is as follows: is the proposed use a continuation of the current non-conforming use? For a use to be determined a continuation of a legally established non-conforming use, it must have the same nature and extent as the recognized non-conforming use. In this matter, the reference point is the nature and extent of the use of the location as of June 5th, 2019, as determined by the Development Review Board in case file DB 24-0002, resolution number 429, and affirmed by council in its order on appeal. As discussed in the council staff report and summarized here, the city is entitled to draw distinctions between uses. Further, once the city draws distinctions between uses, it is entitled to determine that certain uses are beyond the scope of a recognized non-conforming use when there is no evidence of them at the relevant time, and therefore determine that there is no continuation with respect to those uses. Based on the application materials provided by the proposed occupant, evidence in the record, and an examination of how the proposed occupant operates locally, the Development Review Board, in case file number DB 24-0003, resolution number 432, concluded the following, as summarized here and discussed in more detail in the council staff report. The appellant acknowledges that the proposed occupant operates home improvement warehouse stores. However, evidence does not support that the current occupant operated in a retail warehouse format or as a home improvement store. The appellant acknowledges that the current occupant and proposed occupant carry different products, and includes a list of products and services provided by the proposed occupant that are not electronics related or included in the products and services provided by the current occupant. Staff has identified the following products, and there is no evidence that Fry's sold these products or these types of products. Large electronic power tools, floor polishers, tools, hardware, chainsaws, flooring, paint, cleaning products, windows and doors, large household appliances such as washing and drying machines and refrigerators, light fixtures and lighting systems, saw blades and patio furniture, as well as live plants in a garden center that would require watering and irrigation. The appellant shows activities that occur or are likely to occur outside, whereas there is no evidence in the record of the current occupant having any operations outside of the building that currently exists at the location. The proposed occupant contains products and activities that extend beyond the scope and nature of those provided by the current occupant. The products sold by the proposed occupant are substantially different than those sold by the current occupant in nature, use, scale, and deployment to the end user. In other words, the proposed occupant's proposed use goes far beyond a mere continuation of the nonconforming use of the location that was recognized by the Development Review Board. The proposed occupant may engage in these uses at the location only if it obtains a recognition of change of use, which is beyond the scope of what may be addressed in the current matter. Staff recommends the council affirm the Development Review Board decision in case file number DB24-0003, resolution number 432, to deny the proposed occupant as a continuation of nonconforming use of the location. Staff's recommendation is based on considerations and conclusory findings discussed in the council staff report and record, and in the interest of time, these will not be summarized in my presentation at this time. This concludes staff's factual report. Thank you very much.
Council, are there any questions for staff on this report?
No.
Okay. Go ahead.
I have a question.
The issue before us in the Class 1 appeal related specifically to a different situation, but it's been raised as an item in the staff report on a couple of occasions. What's the relevance that you see between that action and the current action?
Do you want to take that one?
Yeah, I'll take that. Stephanie Davidson, Assistant City Attorney. The relevance is that in the Class 1 decision, you all recognize the scope of nonconforming use. So you recognize that the nonconforming use at the location, which was the use actually occurring there as of June of 2019, was a 59,400 square foot electronics related retail store. So that's the use that can be continued into the future, notwithstanding that the current zoning in the town center area doesn't technically allow it. So that's the standard, the starting point for tonight's decision. What you're doing tonight is essentially comparing apples to apples or apples to oranges, and you're seeing, like, this is what is protected, which is the Class 1 decision. This is what the proposed occupant is proposing to do at this location. Are they the same or are they different? If they are the same, that's a continuation of use. If they're different, that's not a continuation of use.
So if I'm understanding you correctly, in the first action, it was a question that related to specifically what is the non-conforming use.
Right.
And didn't relate to any future use that might be used.
Right.
This appeal relates to a specific use.
Yeah,
correct?
what
Proposed
Home Depot proposes to do at the location.
Okay.
That's really the core of the decision before you tonight.
Thank you. So just to add some other terminology here that we've been using, we already had an appeal, a separate appeal that has now been, we had a DRB case appeal to the city council about and it was the Class 1 appeal. And that was, as you said, to determine what is the non-conforming use.
Right.
And that is an electronics retail store, 159,000 square foot
Right.
building. And that is now on appeal.
Right.
And now, just because this isn't standard terminology that everybody goes around talking about, now we are doing a Class 2 appeal.
Yeah.
So the Class 1 was determining what is the non-conforming use. That has been determined by the city council. We confirmed the DRB, and then that has been appealed by the applicant to the LUBA. And today, we are here for something different. We are here for a Class 2 appeal. And would you please just once again describe it under that title of Class 2 appeal?
Yeah, I mean, in simple terms, the way I think about it, the Class 2 appeal is really about, is the Home Depot's proposed use. So this is difficult because the Home Depot doesn't currently occupy the location. We have to think in terms of their proposed use of the location. Is that Home Depot proposed use the same as the recognized non-conforming use, which was the decision that was made in the Class 1?
And which is an electronics retailer.
A 159,400 square foot electronics related retail store.
Thank you. So there are lots of things people could talk about with relation to this topic, but at this hearing, that's what we're talking about.
Right.
And Mayor, I also would like to add, and so the council, what you are considering is, the DRB made the decision in their public hearing and their review to deny that the proposed occupant is a continuation of use. And so that's the substance of today's appeal,
Yeah.
which is that Development Review Board decision that said, no, this is not a continuation of use.
And again, can you state the actual use when you say continuation of use? I just want to be real clear on that.
The recognized legally established nonconforming use, which is a 159,400 square foot electronics-related retail store.
Thank you. Go ahead.
I just want to be sure that I understand correctly. So I understand the clarification of the two different separate appeals. In this case, the council has made, well, let me go back. When you say the appeal is of the DRB decision, we are not acting on the application. Is that correct? Or am I incorrect? We are acting on, do we support, or was the decision of the Development Review Board correct and consistent with the code, the determination of nonconforming use? Is that correct?
I would make a subtle distinction. This appeal proceeding originated with the application. The original application is an important part of the record.
Yes.
It tells you what they were proposing to do in the first case. But technically, the decision before you, what has been appealed is the DRB decision. So in a way, both are true. But if it's helpful to think of it this way, the application is part of the record that you are reviewing as you consider the DRB's decision.
And we can be assured that the information that came to us is only the information that was provided to the Development Review Board.
That was the record that was provided to you, yes.
So no, I mean, there isn't any new information
No.
that has been,
You're only reviewing the same information that the
Very good.
DRB reviewed.
thank you.
Yeah.
Council President Ockerville?
I think my question might be better suited for the applicant, so I'll hold on to it. But if the applicant refers it back to staff, then there's another opportunity to ask staff, correct? So I'll just hold on second thought, I'll hold my question.
Okay.
All right, I'm not seeing any more questions for staff at this time, so I will now ask the appellant to come forward and present its case.
Excuse me. Not yet. Yeah, no, I've got it. Thanks. All right. Good afternoon, everyone. Appreciate you guys having us here again and taking the time to hear this application and appeal. For the record, my name is Keenan Orden Bacallion with the law firm Schwabe, Williamson, and Wyatt. My address is 1211 Southwest 5th Avenue, Portland, 97204. I'm appearing today on behalf of the applicant appellant, Home Depot. With me today is Dan Zaldak with Lars Anderson. Also online is Barry Simmons with Home Depot. Both their addresses were listed on the speaker card, but they'd be happy to repeat them for you if you'd like when they give their testimony.
May I ask a question?
Go ahead.
Is Mr. Barry, oh, here he is, okay.
Yes.
Never mind.
He's also behind you.
I didn't see him at first. Okay, gotcha.
Yeah. And so, yes, Mr. Simmons is going to be presenting later on. And so if you have questions specifically for him, he will be available as well. Okay, so I think today's presentation is going to be hopefully a little quicker than last time. Really what I'm going to do is track what was detailed in the staff packet and the staff report, which was presented just recently by Cindy and Stephanie. So I think starting off, there are two fundamental disagreements between the applicant and city staff. I think we would reframe the description of those two fundamental disagreements a little bit from how they are described in the staff report. But I would say the first disagreement is really just the classification of the nonconforming use that was occurring at the time of nonconformance on June 5th, 2019 at the subject property. Now, Mayor Fitzgerald, you just went through this with Stephanie regarding the description of that use. You also noted that it is under appeal at LUBA. Frankly, we disagree with the classification of the use. The decision you made in the class one, we believe the use was a commercial retail use, not a 159,400 square foot single user electronic retail store. That is fundamental to this application, the continuation of use, because if it turns out that LUBA overturns your decision and the use is defined as a commercial retail use, we believe that this application to continue that use is also going to be granted because we believe Home Depot is a commercial retail use consistent with Fry's operations at the time of nonconformance. Second disagreement is whether the local government should exclusively rely on the original land use approval, the 1991 decision. I'm really not going to go all the way back into that as much detail as I did the first time because that was quite a detailed process. However, we disagree that the 1991 decision is irrelevant. I think to say that is actually a little absurd because it is the original land use approval that approved first Project Thunder and then the Fry's Electronics use of the subject property. They had to operate within that use at all times until they ceased to operate in 2021. So if they were to exceed the scope and bounds of that 1991 approval, they would be operating outside the bounds of your code and the law. So that would trigger a code enforcement case. For all intents and purposes, the 1991 decision defined the parameters of the use. So I do think it is an essential component to determining whether or not the use that was occurring at the time of nonconformance is consistent with Home Depot's proposed use. And we do think that Home Depot's proposed use is consistent with what was described in the 1991 decision. Is that the only piece of controlling authority and evidence? No, but we do think it is one of the most important, if not the most important. A couple other issues raised on the beginning of the staff report. In our appeal, we noted that we challenged the adoption of the staff report by the DRB as part of their decision. We're not challenging that the DRB is allowed to adopt a staff report. What we are challenging is the findings and conclusions of law within the staff report. The staff report, again, for all intents and purposes, was the decision of the DRB. They adopted an ordinance, and all of the actual substantive findings were in the staff report. We disagree with those findings, which is why we noted it in our appeal. Let's see. Another procedural issue regarding our just kind of overall general challenge to the process here. It was noted that on November 23rd, 2023, staff sent us an email noting that we had applied as a Class 1 application to determine the nonconforming use and that we could continue. And they stated that the question of continuance required discretion and interpretation of Wilsonville's development code, which required the Class 2 procedures to be invoked. I think one of the critical components that's been missing from staff's description of this email is, and it's in the record, you can certainly take a look at it, I believe it might also be in the meeting packet. It noted that if we didn't respond, they would continue to process our Class 1 application as is, and the continuation of use question would not be touched, and we'd have to apply for a Class 2 application for that. We did not respond, and then we applied for the Class 2 application. So we actually followed one of the options that was provided to us within that email. We didn't, disregard staff and go out on our own and do something that was wholly outside of what was discussed. So I just think that clarification is important here.
May I have a question here, or wait till the end?
You're the presiding officer. You can.
Just so we don't lose this, if you don't mind, if I could.
Sure, absolutely.
When you said you didn't, this question of did you respond or did you not respond, are you talking about within the time frame of when, up until that required deadline, or?
Yeah, so again, I might be wrong on this date, so I don't want to state this definitively for the record, but I believe there was a 5 to 10 day period where if we responded, they would take an action to process the application differently, whereas if we did not respond, they would continue to process our Class 1 application requesting a determination of nonconforming use at the subject property, but not the question of whether Home Depot could operate as a continuance of that nonconforming use once it was determined. So there are two separate questions.
And that was
here.
about the Class 1.
Yes, so initially we submitted only one application, and that was submitted under the Class 1 procedures because, I guess to flesh this out a little bit more, Wilsonville's development code draws distinctions between Class 1 and Class 2 applications. Class 1 applications are ministerial, they require no discretion, there's no question or uncertainty as to the history of the property. I believe that's directly out of Wilsonville Development Code 4.03001A7. We believe, based on the information we submitted in our application, there is no question as to the history of the property. We did not think that discretion needed to be exercised to determine, one, that there was a commercial retail nonconforming use of the property, and two, that Home Depot was allowed to continue under that nonconforming use. That was our position.
Okay,
Staff
thank you.
disagreed, which is the impetus for the email.
I just wanted to clarify, or, the time frame you were talking about. So
Absolutely.
Go ahead.
Of course. So again, after that email had been sent, after we had submitted our Class 2 application, or even potentially before, the city staff issued a determination, the planning director determination on the Class 1. We believe the city's initial decision on that Class 1 exceeded the scope of what was allowed under a Class 1 application and decision because it included significant amount of subjective discretionary statements regarding the nature and extent of the use, the scope of the use. It was defined as a Fry's Electronics at first and then a single user electronic retail store. Our our understanding of the Class 1 application was simply that the city was supposed to determine, yes, there is a non-conforming use there, and not get into the nature and extent of the use. We believe that was going to be processed under the Class 2. That may be a difference of opinion with staff, but that is our logic and reasoning and why we are in this kind of slightly convoluted procedural process. I just want to clarify for the record that, we at all times tried to work with staff on this to try and, clarify the procedural situation. Unfortunately, we just haven't been able to come to an agreement, which is why we have this bifurcated Class 1, Class 2 process. Moving on, I think there was a question of the evidentiary standard or the standard of review here. We agree the substantial evidence standard is material to this application. We note that the city council's decision will not be entitled to deference under the Saporin case because we do not believe that there is a Saporin level interpretation of the Wilsonville Development Code here that would entitle it to deference at LUBA. The substantial evidence standard, I think that's interesting. It is true that city staff doesn't necessarily need to introduce any evidence to rebut the evidence we submitted. However, your decision at LUBA still needs to be supported by substantial evidence. So if you find that our decision or our application materials and subsequent evidentiary submittals are not substantial evidence that Home Depot can continue as a non-conforming use of the property, that still needs to be a conclusion that a reasonable person could agree with. So it cannot just be a carte blanche, we disagree. Moving on, what is the current non-conforming use? I kind of jumped the gun on that one a little bit, but we believe it's a commercial retail use. We believe that's what was approved in the 1991 decision. We believe the distinction regarding the different types of products that were sold at Fry's and Home Depot is not necessarily material to this application. We're not arguing that Fry's sold chainsaws. What we are saying is that both of the operations were aligned as commercial warehouse retailers in a warehouse format, big box. They had the same service offerings both to the public and professionals. They offered technical support. Mr. Simmons will get into much more of the detail of that in his presentation. So we believe the underlying use was the same, even if the products necessarily weren't all identical. Yes, in terms of the change of use question, because obviously if this isn't a continuation of use, it would be a change of non-conforming use. We believe the nature and extent of the lawful use that was in existence on June 5th, 2019 is identical or very similar to what Home Depot is proposing. Therefore, we do not think that we are proposing a change of use. We're proposing to continue the non-conforming use that was established in June. Again, like I noted, both Fry's and Home Depot are warehouse retailers. They operate in the same manner, even down to the store layout and service offerings. To draw a distinction between these stores is, in a way, slightly absurd because it'd be like saying, a former McDonald's cannot, for instance, become a Taco Bell. No one's arguing that you can get a Big Mac at Taco Bell. However, both are fast food, restaurants, right? The underlying use is the same, even if the product that is retailed or sold may differ in some respects. I guess, I think that's kind of where I want to stop things and turn it over to Mr. Simmons to kind of flesh out a little bit more of what Home Depot's operations look like and their, similarities and almost identicalities to Fry's. So with that, I'm going to share my screen and turn it over to you, Barry.
Thanks, Keenan.
Yeah.
Good afternoon, Mayor and council members. I'm Barry Simmons. I'm a real estate manager with the Home Depot. Go ahead. Yeah, thank you. All right, so the first is this is a continuation of commercial retail use. Within the staff report, the city staff provided the outline or the as-built drawing for the Fry's. We wanted to match that up with what we're proposing, what our plan is for the existing building. The city has already determined that the building is a non-conforming structure, and as you can see, our operations would fit within that non-conforming structure. This is not an expansive request. This Home Depot as being proposed would be a non-prototypical Home Depot, and we would not have an exterior garden center, so we're not looking at expansions to the building. Next slide. So again, continuation of the commercial retail use based off of what was approved in the by the previous user, previous development proposal. We're actually proposing less traffic impacts than what were originally designed. We believe we're going to have, and again, it's difficult to compare based off the fact that the Fry's has been out of business for a couple of years. The original design for that site had 4,100 traffic trips on a daily basis. We are not going to have anywhere near that. So the infrastructure should be in place to handle certainly what we would expect and certainly be not an expansion. We're also looking at less parking impact, The existing 15-acre site has about 840 parking spaces. A Home Depot doesn't need that many. We're only looking at about 400, which is a difference of about 5 acres of real estate. And as you can see to the right column here, that additional 5 acres of real estate is an opportunity to redevelop that. And we believe that could be, that redevelopment could benefit the town, could further the town center plan, and whether that's multifamily, other retail, whatever. And certainly Home Depot is willing to work with the city in order to fully utilize that 5 acres that would be made available by our use. Next slide. So the next few slides I want to run through pretty quickly just to address the similarities and the continuation of a commercial retail use between the previous user and the proposed use. Many of these came out of the staff report, some of which we found on our own. But again, the point is really they're very similar operations, and we believe this is an absolute continuation of commercial retail use and not an expansion. As you see here in these particular photos, typical for any commercial retailer, there is going to be a point of sale, maybe referred to as a checkout station, located at the front, usually by an exit. And as you can see, our store's layout almost identical to the existing, the current Fry's or the current user Fry's. Next slide, please. And again, continuation of commercial retail use. Unfortunately, part of commercial retailing is the processing of returns. We do have to take items back on occasion. And as you can see, the return station for both stores is almost laid out identical. Very similar parts or similar locations within the store. And also, as far as services that the previous user exercised and what we, Home Depot, would exercise is opportunities to order online and pick up in store. And as you can see by the banners on the left and the displays on the right, that both of those options would be available for each user. Next slide. Again, highlighting some of the similarities between the uses between the previous user and the proposed use at this facility. Clearly, you can see this is a warehouse. Both are warehouse style stores. You can see up into the beams in the roof. No ceiling tiles are in place. There's lots of signage that directs customers to the correct parts of the store. The use of that wayfinding signage and aisle signage is a mark of commercial retailers, particularly large boxes, for customer convenience and navigation around the store. So again, highlighting the similarities between the uses of the current user and the proposed use. Next slide, please. And here we have aisles from the old Fry's and a typical Home Depot, indicating that the product aisles also are numbered for convenience and easier navigation, and each has a list of the product categories that are within those aisles for customer use and convenience. So you can see that the layouts between the stores and how the products are arranged on the shelves, how they use end caps, how they maximize the space, and how they use signage for navigation for customer use is consistent between the current retailer and the proposed retail use, both being commercial retailers. Next slide, please. This is to demonstrate the services that were offered between the two stores. On the left, you see a workstation at the end. There's an end cap there that reflects where a customer may go to order a customized hardware package for a computer with customized software packages, hardware with a customized software package. On the right, the technical support that Home Depot would offer its customer base includes potentially, in this case, paint and a customized color palette, being able to match any color that any particular customer would want. So technical support and customized product offerings were available both with the previous user, or the current user, as the city staff would say, and the proposed use. Next slide. So again, to show the similarities between the previous user and the proposed use, these reflect services that were offered to customers away from the store. As you can see on the left, this is a banner that at the time Fry's was offering same-day delivery to the residents. On the right, we show a advertisement, effectively in-store advertisement for delivery of doors and windows. Again, different products, however, similar services. And again, technical support, as you can see, the customer assistance sign for the computer department, as well as the, unfortunately, the empty chair at the doors and windows station, where customers could go up and talk to a sales associate about any specific issue they may have with regard to a potential product or purchase they may make. Okay, next slide. The city staff showed this photo of our washers and dryers. We also want to show that this is a similar layout showing the warehouse style retail component, where products are obviously just laid up in lines, and a potential customer could walk up and down and look at the different options, whether those be this time hard drives with monitors or washers and dryers. Our store layouts were even similar, as you can look at those pictures. So the products were displayed in similar manners between the current user and the proposed use. All right, next slide. This is just another example of product displays above products for sale. Now, obviously, in the Fry's picture to the left, the shelf appears to be empty, but you could visualize where boxed products were sitting there for the customers to pick up, similar to the photo on the right of a typical Home Depot store, where you can look, touch, feel the display model to make sure that it's exactly what the customer wants, and then there is a product in a package immediately underneath that a customer could pick up, put in their shopping cart, and carry it out of the store. The next shows similarities between the current user and the proposed use of how our merchandise is displayed. As you can see in both of these images, that both retailers, commercial retailers, use pegboard displays, or what I refer to as a pegboard displays, to select or to display select merchandise that will be sold on each individual basis. And again, whether it's a hammer or something else, we don't believe that that is a significant difference, but we believe we're both commercial retailers. Again, similarities in product displays. This shows a variation in display techniques to display merchandise. Again, whether it's one product or another product, you can see similarities in the merchandising techniques that Fry's used as a commercial retailer, that Home Depot would use as a commercial retailer. Again, we may have different products, but we display them similarly in order to attract our customers' attention. And do also want to point out these are, not only do we sell end items, whether it's a hard drive for a computer or the hardware for a computer or a circular saw, we also sell the components, in our case, blades or the game component kits that you see on the left. So we sell the end items and we also sell the components, and that's the same for the current user and the proposed user. Okay, next slide. Drawing another similarity between the current user and the proposed user. Floor stacking products for seasonal promotions and higher volume sales seasons. As you can see on the left, they are promoting several items. They're stacking those items in the middle of the floor. It's obviously the holiday season with the trees in the background. You could tell that this is preparation for a seasonal sales, Christmas rush in this case. I will say that for the Home Depot, our Christmas actually occurs in the springtime when everyone is getting their yards up to their standards. So we have more sales events and higher promotions, but nonetheless, we approach it in the very same techniques where we put products on the floor and stack those up, sale signs, and people will take the products that they choose. All right, next slide. As far as ancillary items, I think the city staff showed that in their Venn diagram. I hadn't seen that Venn diagram before, so that's interesting. But this is to show you that there is continuation of retail use and similarities between further similarities between even the products and how they're displayed. We have computer gaming chairs on one side, patio lawn furniture on the other. So not only it shows the breadth of products that both commercial retailers had within their store. Next slide. And again, this is another slide that just shows ancillary sale type items, similar merchandising techniques, where you can see where both of these displays were provided by the manufacturer in a display to be floor stacked in a high traffic area. It is almost the exact same merchandising technique both between the previous user and the proposed user for the store. So the last slide, I think it's the last comparison slide that I have here, but you could tell that these stores are similar. We may sell different products, and we fully admit that, but we don't believe we are a different use. We believe both are commercial retail uses. And we both have a similar goal, or had a similar goal, of excellent service, branded customer experience from the beginning to the end. So from the time you pick up your shopping cart, you go through the store until you return your shopping cart. We want to have a branded, similar experience that exceeds expectations for our customers. So we talked about how our city staff may try to show or have talked about how they are different. We believe that the uses are the same between the previous user and the proposed retail use. We believe those are all commercial retail use. And here are the comparisons. We both offer appliances. They may look different. Tools, they may look different. Measuring equipment, technical expertise, service. We both offer delivery options. And we both market to professionals. Even Fry's was marketed as to everything that from the hobbyist to the Silicon Valley professional is one of their slogans. So continuation of commercial retail use. This is planned as a non-prototypical Home Depot store. We understand that it's going to be slightly different based off of the limitations of working within the existing building. We do plan to occupy the existing structure. We believe that is a sustainable use of that existing building. And as I said earlier, the city has already confirmed that that building is a non-conforming structure, would be available for use. Exterior modifications, primarily maintenance related. We are not going to have a exterior garden center. The city did call out our lumber pad, and I believe they fairly described it. I will say that flatbed trucks are off to 53 feet. They just don't have a box to them, but they're the same trucks. The last bullet I wanted to point out is Home Depot direct to customer delivery capability. Over the last handful of years, we have added about 50 million square feet of distribution capacity for direct delivery to our customers. That includes appliances and bulk items. So if a pro item, I know this came up in an earlier meeting, if a pro wanted to order a large quantity of materials, that material would not flow through the store. The sales get attributed to the store, but that large quantity of material flows directly from the distribution center straight to his job site. So that is innovations that we have made within our distribution network, and I believe that's a result of online ordering capacity, which probably was one of the reasons that the electronics related stores did not generally have not survived. So I know it was discussed earlier in our Class 1 application. I want to bring it up again as to how what we're proposing fits within the town center plan. As you can see, this is an exhibit taken directly from the town center plan. I do have an inset there in orange, and I will show you that in a minute. But as a legend to this, I'll go ahead and tell you that that white building is the existing building. This was inclusive of part of the Phase 1 town center plan. The white buildings are existing. The buildings that are in the purple indicate new development. So as you can tell, we feel that we are in alignment with the town center plan. And based off of our reduced demand for parking, that we would open up the 5 acres on our front outlots and to the side of our building for the future new development that, again, could be used in coordination with the city for furtherance of the town center plan. And these are just a couple of examples. I think we addressed on some of these earlier. I'm not going to go too much into them. These are just these are proposals, if nothing else. It's not a lot of detail behind them, but certainly a rendering of what could be as far as multifamily usage for the outlots that are that would be created out of our additional 5 acres that we don't need for parking. This is just a rendering of what might exist or could exist, assuming that that we were able to occupy the building. We think that oh, that's fine. Yeah, this is just another view of the same image. Go ahead, next slide. And just to align these two, that inset that I highlighted earlier, this is that same inset kind of rotated so I could kind of line these two up so you could see that what we're proposing and what the, not necessarily a proposal, because we haven't hired an architect or anything, but just a rendering of what could be and how that may align with the town center plan. I think we were asked one time how far we are in the design of this, but we actually have to get the use approved first. So, but the Phase 1, one other comment there, the Phase 1 is expected to take, I believe, according to the town center plan, 20 plus years. So, and again, I highlighted on some of these in the Class 1 application, but just to bring those back to your attention, Home Depot and multifamily, multi-use development projects. We've done that in multiple locations across the country. These are actual pictures of a recent project that was completed in Linwood, Washington, not too long ago. This is close to your neighborhood. The next is a rendering of a project in North Surrey, Canada. You can go ahead and flip to the next slide on that. And this is what it looks like today. As you can see, there's a Home Depot in the background in the middle of a multi-use development that includes multifamily or residential. So it's not uncommon. These are just a couple of examples that are kind of within your neighborhood of what we've done, similar things with new development. So the last couple of slides are just highlights of Home Depot. I do want to point out our focus on associates there. 90% of our leaders started as hourly associates. I think that's a great one to highlight. And then our community support, we do a lot of work with veterans and we dedicate a lot of local service hours. But I will let you guys, I won't read that in detail. And then sustainability, we've received several awards for our sustainability. We certainly like to look at how to be responsible, both from our operations perspective and how we run our stores, and also from the products that we select to sell to our customers. So we look at it from both perspectives. Next slide is the what we believe is also just a benefit to having a Home Depot in your area, in your market. The volunteer hours, these are stats from Oregon as a whole, like within the state of Oregon, the stores that we have, and then the volunteer hours, again, the total economic impact that Home Depot has provided to various communities around Oregon. And we believe it's a benefit, and we believe that, again, the economic activity there within the town center area would be a benefit. Well, that concludes my presentation. Certainly would be willing to take any questions.
Thank you. We will now move to asking the City Council if you have any questions for the applicant.
Excuse me. I've got a couple more remarks to my presentation.
Okay.
I just want to make Barry available right now because he just gave the presentation and it's fresh in your mind.
Okay, that's great. Thank you. So maybe just while we're here, since he just finished, are there any questions at the moment? And then we'll continue.
Mayor, I will have a question for Barry, but it will be aligned to some
Okay.
comments, so I'd like to hold that.
Okay, thank you very much.
Yeah, then, thanks.
I appreciate it, Mayor Fitzgerald. Okay, thank you, Barry. I really appreciate that. I know we're getting pretty good at this presentation by now.
Thank you.
Let me just stop sharing my screen here. Okay, so I think a remark that was brought up in the staff presentation about the city being entitled to draw distinctions among uses, the applicant's not disputing that whatsoever. But here, what the city is doing is not drawing a distinction between uses, it's drawing a distinction between certain products that both the commercial retailers actually retailed, right? And I think that's kind of what Barry's presentation was focused on, is the similarities in both Fry's operations, which were occurring at the time of nonconformance on June 5th, 2019, and Home Depot's proposed operations. We believe that Home Depot's operations are consistent with the existing nonconforming use there, which is a commercial retail use, and we believe that Home Depot should be entitled to continue that use. I think I'm just going to run through the rest of this pretty quickly here. There's a couple comments in the staff report regarding the applicant's evidence, so I'll address those briefly in turn. We submitted evidence and testimony to demonstrate compliance with the fact that Home Depot's commercial retail use is consistent with a continuation of the existing retail use. The first item was the 91 decision. We've talked about that. We disagree with staff regarding the relevance of that. I really don't think it's going to be very productive for the city council to, in terms of making your decision to keep going back to that. We do believe the 91 decision is a controlling authority that defines the scope of the use that was occurring at the time of nonconformance. We submitted CC&Rs for the town center area. We submitted those CC&Rs to articulate the subject property has always been understood to be a retail use. We've also been through this process trying to work with staff regarding the CC&Rs and the potential impact they'll have on future development of the town center area. Home Depot is willing to be a partner, and frankly, but for Home Depot coming to the table, it will be difficult for city staff to effectuate the town center plan based on the existence of those CC&Rs and Home Depot's role to play as a property owner within the town center plan and the fact they are covered by those CC&Rs. Again, like I said, Home Depot is trying to partner with the city. If the city was to approve this application, we would certainly accept a condition of approval regarding amendments to the CC&Rs, which is, and we would also work with the other stakeholders in the area to move that forward.
Can you restate that? You kind of ran through that super fast, so we can make sure to hear it all exactly.
So were you to approve our application, find that Home Depot is a continuation of use or otherwise modify the previous Class 1 decision, we're prepared to accept a condition of approval obligating us to commit to amendments of the CC&Rs. The CC&Rs are a controlling factor in the development of the town center area, and there have been several amendments, and there is currently a requested amendment. And what we're saying is we would accept a condition of approval for this application that would obligate us in one way or another to commit to those amendments of the CC&Rs. And we would also commit to mobilizing the other stakeholders that are subject to the CC&Rs, including the declarant, to commit to those types of amendments. So,
Okay, I heard you, thanks.
yes, I was going to ask if that answers your question.
Yeah, that got it, thanks.
Very good. I think the certificate of occupancy question, land use planning still needs to sign off on building department certificates of occupancy. We submitted the certificate of occupancy for the Fry's, which listed as a retail use. We also submitted the certificate of occupancy for the Ace Hardware, currently in the town center area, which is also defined as a retail use. There's no distinction or subset within that type of retail use. And although we are not saying building code classifications are identical to land use code or land use classifications, what we are saying is that land use plays an important role in signing off on those building approvals. So there is some interplay between those distinctions, or between those two departments of the city. And the fact that both Fry's and the Ace were defined as retail uses, we do think is substantial evidence and supportive of our position that Home Depot could continue as a commercial retail use similar to Fry's. I will save the case law analysis for my quick rebuttal. We did want to raise the codification requirement. We believe there's some dispute with city staff regarding the applicability of codification in this case. We're not saying that the city's reliance on Oregon's non-conforming use case law is a violation of the codification requirement. We acknowledge that most of the non-conforming use authorities for cities in Oregon comes through the case law instead of statute. What we're saying is that neither the planned development commercial zoning designation for the property prior to becoming non-conforming, as well as its current town center zoning, drew a distinction between types of retail uses. So there was not an electronic retail use subset and a hardware retail subset. There was just a retail use. And so for the city to make its decision that the non-conforming use was a single user electronic retail store, I believe that goes outside the scope of both the property's historic zoning classifications as well as their present ones. And we think that is what violates the codification requirement.
Can I ask a question?
I think,
Can I ask a question on your statement that you just made?
yeah.
When you talked about the codification and the definition as a retail use, Whose definition is that?
That is the city's definition, both in the property's historic plan development commercial zoning code. There's a list of allowable uses, and the use is listed as retail, not electronic retail or hardware retail. What we're saying is there is no distinction there, which is consistent with our overall argument that there is no distinction between Fry's and Home Depot's operations. That's also true for the city's current town center zoning ordinance, which does not draw a distinction.
You weren't talking about specifically this property.
Well, I was saying that this property had the city's historic zoning designation as well as its current town center zoning. So the zoning did apply to this property. So I am talking about the property. I think the only other thing I wanted to raise before the request for relief is preservation of arguments. That's been brought up both in the Class 1 and the Class 2 proceedings. Staff has several times alleged that we didn't preserve certain arguments, legal arguments. We've been unable to find any authority in the city's code that requires us to preserve certain legal arguments throughout the local process, the DRB to the city council level. We certainly recognize this is an on-the-record appeal, meaning that we cannot introduce new evidence, but we are introducing, we also have not conceded that we are introducing any new arguments, but were we to introduce new arguments, we also don't think that is necessarily prohibited in the first place. I think specifically in the staff report, this relates to our procedural, our allegation of procedural error regarding the Class 1 and the Class 2 procedures for this application. We believe that was raised both orally and in written testimony below, and we're certainly raising it again here. So I think I just wanted to clarify that point for the council. With that, I think we'd like to just simply request our relief here. I think there's several options the city can take here were they to approve the application. First, and I think the best way to potentially resolve this procedural situation would be for the city council to approve the continuation of use application, also modify resolution 429, which was the Class 1 decision, to find that the use is a commercial retail use. We understand it's your prerogative not to do that, but that is our request. And so I think that would probably clarify things from a procedural standpoint and put everything under one umbrella and allow us to move forward with the project. Alternatively, you could simply find that our proposed Home Depot operations are a continuation of the non-conforming use you found in the Class 1. Admittedly, I understand there's probably some significant hurdles to get through there, but that is an option for the city council to do so. With that, I'm happy to take any questions. Barry's available, as is Dan, so.
Okay, Councilor Dunwell.
Mayor, thank you. I actually, as all of you presented the details, and first of all, Mr. Simmons, it's good to see you in the daylight. I know you were here very late last time, so thank you. I do want to say, and just step back for all of us as we look back and look forward on this, my perspective is as elected officials, I just want to say that we have an obligation to support and uphold the city code and ordinances, including master plans put into place by our predecessors. We also have an obligation to challenge those actions and those decisions when appropriate. What I cannot square, though, is how or why, as an appellant, you would go back to a 30-plus-year-old description of the property in question, rather than address and respect the 2019 master plan and file a change of use. I argue that your approach attempts to handcuff this council, going back in time until you found a ruling that supports your position. I believe our staff has done an excellent job in providing case law to support the decision, and I know that you feel differently as you've stated. I also want to address, Mr. Simmons, that there were significant elements of your presentation that were marketing, and that was outside of the scope of today's council meeting. As much as I appreciate the story that you're trying to tell, that's marketing, and specifically how you can help our city realize the town center master plan. And given all of that put together, I really have to wonder, as a citizen of this community and as an elected official, why you didn't just file a change of use, respecting the 2019 decision and using Mr. Simmons' initial slides to support the value of that change of use. So, again, these are questions of mine and perspectives. I don't expect you to address those or rebut those, but I do want to be on the record that that's where I'm coming from.
Understood. Yeah, and I mean, I don't think it's really productive to kind of go back and forth on that. I can hopefully provide some clarity as to your question. So we did discuss the change of use pathway with city staff several years ago, as well as in a most recent meeting last month. There are significant impediments and ambiguity related to the change of use process that, frankly, we have made a decision at this point are untenable to proceeding forward with. The non-conforming use pathway is provided by your code. It is codified. It's WDC 4.189, if I'm not mistaken. And so it is an allowed pathway for an applicant to proceed. So we weren't necessarily going outside the bounds of the code when we submitted this application. And non-conforming use analyses are, frankly, historical. I was a history major in college. I really enjoy going through these projects because they require you to look back into the past and find out what was allowed at the time of nonconformance. And so, although we certainly respect the planning effort and intent of the town center plan, this was an available pathway for us to take, and I think that it made the most sense for us in terms of our objectives and goals to go that direction. That said, I think a lot of Mr. Simmons' presentation detailed how we can be a willing partner with the city to effectuate the vision of the town center plan. So I think we're trying to balance this, and although you might disagree, we are not ignorant to the concerns that the council has.
I understand that, but what I'm trying to say is that is outside of the scope of today's conversation and today's decision in this hearing. As much as I appreciated hearing that, I do believe that it was outside of the scope, and in fact, I believe it was inappropriate to include that in today's presentation. So again, rather than going back and forth, I will go in and reiterate, I do not understand why you did not rely and why you did not respect the 2019 decision, specifically that it was a retail store. Retail electronics store, related store, which was specifically outlined in that 29 decision. And correct me if I'm wrong, City Attorney or Assistant City Attorney, but is that correct?
I think during this part, if you have additional follow-up questions, we can talk about that during our argument.
Yeah. Okay.
I think we're,
All right.
we're good. Thank you.
Okay, I think Councilor Linville is next.
Thank you. Thank you for your presentation. And Mr. Simmons, good to see you. I was not here at the last meeting, so it is nice to be here. I have a couple of questions for you that relate to just trying to really understand the language, because I think you're making a considerable emphasis on the words commercial retail, at least today, in your presentation. But as I look back on the record, there have been a lot of other words that have been used. Warehouse retail being one of those. Commercial didn't show up for quite some time. And I looked at information on the Home Depot website, and clearly there isn't any reference to commercial retail. It says it's the world's largest home improvement retailer. And so I'm struggling with, and Fry's, it very clearly, as Mr. Simmons mentioned, is defined as a Silicon Valley retail electronics store on their corporate website, which is now gone, but that's the definition from the Three Brothers when they closed the stores. So I'm confused about which language you're actually trying to use as we move forward. So could you respond to that, please?
Absolutely. And are you asking me? I'm Mr. Orton Battalion. Barry Simmons is on Zoom.
I'm asking you.
Okay. All right. Awesome. I thought you were addressing him originally. So thank you for the question, Councilor Linville. I appreciate it. And I recognize the potential confusion regarding the terms and uses here. Definitely agree Fry's described themselves as an electronic retailer. Home Depot has described themselves as a home improvement retailer. Those descriptions are different from our perspective than the actual legal land use classification under non-conforming use law in the state of Oregon, as well as the Wilsonville Development Code. So they can be the same, but also different. I know that might be confusing, but there's a difference in the legal effect of a commercial retailer and the marketing and kind of client-facing description, which is a home improvement store and electronics retailer. Like I noted in my presentation, both the city's current town center zoning code, as well as the historic zoning for the property, do not draw a distinction between retail uses. So they do not draw a distinction stating electronic retailer or home improvement retailer. So I think there's a difference between, again, the marketing side of things and the legal classification of the use. As for the use warehouse retailer, my understanding is we use those terms to describe the similarities in the store layout for Fry's and Home Depot. They are both set up warehouse style for their retail operations, but the legal classification of use is commercial retail. So I hope that it answers your question, at least from our perspective.
Well, it looks like the information on the application for your Class 2 review that was submitted on December 15th of 2023 specifically requested, as stated in the application, a Class 2 staff interpretation to confirm that the Home Depot and Fry's Electronics are both warehouse retail uses.
Understood. And I think
Which is different from what we heard today. We heard commercial retail, commercial retail.
And I think we've been consistent with the use commercial retail since January or February of this year in both the Class 1 and Class 2. I think initially we were unclear exactly what the classification would be when we submitted that application, but subsequent to that, we have, we've identified the 91 decision, which we attached as part of our application. It's listed right on the top, and there was a slideshow in our application materials showing this before the DRB, approval of a commercial retail use. So once we kind of focused our analysis on that, we have been consistent with the use commercial retail for several months now. And that is our position on the record.
Okay. So I'm just clear, the question that you are asking for us is this a continuation of the non-conforming use of a commercial retail store?
I think our question and staff's question is different. But yes, what we are asking you is to determine whether Home Depot's operations, as described by Mr. Simmons in his presentation, as well as our application materials in the record, demonstrate that Home Depot's proposed operations are consistent with the operations that were occurring at the time of nonconformance, i.e. Fry's, and that we can therefore continue under the umbrella of those nonconforming rights.
And so that brings me to my last question. And just so I'm really clear, what do you believe is the point of nonconformance on this site? What date and time was the point of nonconformance for this property?
I think there's no dispute between city legal counsel and the applicant on this. We agreed the time of nonconformance was June 5th, 2019, when you guys adopted the town center plan, because that is when the property's historic plan development commercial zoning was replaced with the town center zoning. And at that point, there's a provision in your town center zoning code that prohibits retail uses exceeding 30,000 square feet. As we've kind of gone around in circles with the square footage here, we're talking about 159,000 square feet, so it grossly exceeds that. It would not be allowed if we were to submit an application with that proposal to staff right now. That would be inconsistent with your zoning code. That's the purpose of the non-conforming use application.
Okay, thank you.
Thank you for the questions.
Go ahead.
I had a question for you that the actually staff's presentation helped kind of bubble this one up, but I thought you were probably a good person to help answer it. And that is, there's been some discussion, and I know that this was included in the application materials from the appellant, about the lumber pad at the back of the building. And I'm curious how Fry's received shipments and if they had a lumber pad to receive those shipments.
Barry, do you want to take this one, or Dan?
Sure.
I'm happy to also weigh in as well.
Dan Zoldak, Lars Anderson Associates, I'm the applicant. Fry's had a multi-deck on receiving deck, which is, I think, was over 6 truck receiving stalls on what would be the west side of the property. We only need 2 to 3 for our box trucks, and so this would be we would actually have less receiving docks than Fry's has today, because we will basically close down some of the receiving docks on that west end of the property.
Is a receiving dock the same as a lumber pad?
It's receiving goods, yeah. I would say we're receiving materials to stock the store.
Yeah, it's kind of hard to hear. Do you have the light on that?
Both are used to receive goods and to stock the store. They're different materials, obviously, but both are used to stock the store and receive goods.
I think that goes back to the question of distinction in use or distinction in product as well, too. So I think Dan's...
Yeah, it's different product. Both are commercial retail product. Wood is obviously not floppy disks.
Is it an area exterior to the building? They're both, can you help us visualize?
Yeah, they're
what
both
this is?
exterior to the building. A box truck backs up to the physical building and unloads directly into the building. A flatbed truck unloads outside the building and delivers it inside the building.
So it unloads outside the building versus unloading into the building?
Correct.
So there is a distinction with how that occurs. I also wondered if, did Fry's have an indoor irrigation system to support or maintain any of their products?
No, I would assume they don't have an irrigation system, but they have different products inside the building that facilitated their goods and services that they've supplied.
I mean, they might have been watering the Christmas trees, which they were retailing as an electronic retailer. But beyond that, no. I mean, obviously, I understand the direction of your question, Councilor Ackerville, or President Ackerville. It's very well taken, and I think it's very intuitive to this. I think that, again, goes back to whether or not you're of the mindset that we're talking about a difference in product, which is dispositive, or whether we're talking about a difference in use. And so ultimately, that's for you to decide. I think we are clearly of the position that, no, we didn't have an irrigation system, but that is ancillary to supporting our commercial retail use, similar to the fact there are probably aspects of Fry's that Home Depot doesn't operate, but they are all intended in the furtherance of the commercial retail use. So hopefully that clarifies our position.
Thanks for your answer.
Any other questions? I just wanted to say that I do have a question. We made it clear at the beginning of the meeting that we are, we all know from the materials that this meeting is the review of the Class 2 determination by the Development Review Board, which is the determination, starting with that we are working with the city's decision, which I realize you don't agree with. So, I mean, that's fine. You don't have to agree with it. I'm not disputing that you need to agree with it. But the determination was that the non-conforming use was an electronics-related retail in a 159,400 square foot site. And so I feel like you might have come to one meeting and we're going to a different meeting, because we are compelled to attend to the business publicized for this meeting, and we would do that for any and every such meeting that we have. And so, we are. In every case, the Class 1, the Class 2, this appeal, I am basing my decisions on what I understand is what I have done when I've read the 500 and the 1,000 page and all of these documents on my best determination of the Wilsonville Code, Oregon law, and Oregon case law. And through that, I personally felt confident, and that's why I voted that way, that the continuing use was, as we just keep saying, an electronics-related retail store. And one of the references to an earlier case that we looked at was, that we heard referenced, it was Nahoda, it was a Luba case, Nahoda, I believe is what we called it. And what I have in my notes was out of the record, the purpose of the local government proceeding to determine the existence of a non-conforming use is to determine what use existed on the date the restrictive regulations were applied. And we agreed that was June 5th, 2019. So can you just tell me one more time for this meeting how we keep talking of why we keep I guess it's because, why we keep hearing you talk about the commercial retail store in the broad sense, as opposed to the non-conforming use that existed at the time of the land use change, which was 2019.
Thank you for the question, Mayor Fitzgerald. I think that last sentence is exactly the crux of the issue here, is that we don't agree that the use that was occurring at the time of nonconformance was the 159,400 square foot electronic retail store. We believe that was a commercial retail use, which is why we've appealed the Class 1 decision to the Land Use Board of Appeals. For us to argue opposite in this Class 2 proceeding would practically undercut our own appeal, and then frankly just be incorrect in their interpretation of the law and the facts.
Thank you.
Again, the only thing I'd add as well, if you'll permit me, is in a relief, there is a possibility or an opportunity for City Council, based on the information they've heard today, which is all based off of the record on appeal. I have not brought up any new evidence or testimony that wasn't raised below, that, you know what, maybe upon further reflection, the commercial retail, the use that was non-conforming was commercial retail. It was more broad than the limitation of an electronic retail store. And so you do have the prerogative under Wilsonville Development Code 4.02208A3 to modify a prior decision. That would be Resolution 429, and find that the use that was occurring at the time of nonconformance was commercial retail rather than electronic, single-user electronic retail. And to cut the square footage mentioned at this point.
Okay. Thank you. I don't have any other questions at this time.
Thank you for your question.
Oh, excuse me, we have a question from Councilor Linville.
I just wondered, I understand the timing and the application, the Class 2 application was put in, but I'm just wondering, since you appealed, were you already in the track of the application process when the Class 1 decision was made? And why did you not wait for an answer on the appeal before moving forward with the Class 2 application?
So I think the timing is a little more condensed than that. I'm going off of memory here, so again, I don't want to state this definitively for the record, but I believe we appealed for the Class 1 in October. In November, we were notified by staff that there was questions within our Class 1 application that staff believed needed to be processed through a Class 2 process. And so one of the options there was to proceed with the Class 1 and also file a Class 2 application. I think that's verbatim out of the email, for the determination of whether Home Depot constitutes a continuation of the non-conforming use. And we chose that option. So unfortunately, from a procedural standpoint, we've had these two applications proceeding along separate tracks, but on a similar time frame since November of last year, or December 4th, actually, is when we submitted the Class 2. And so we didn't appeal the Class 1 decision until January, at which point the Class 2 had already been submitted, if I'm not mistaken. So we didn't even know we were going to appeal until we received the decision on the Class 1. So I agree, if we could go back and clarify things, I think all of us would like to have found a way to make this work a little bit more smoothly. But again, I just want to be careful that we're not sending a narrative here that we were just full steam ahead, ignoring all of the warning signs in front of us. We're in a difficult procedural situation, and I think we've made the best out of it. And ultimately, I think it's in the hands of LUBA now, at least for the Class 1.
We now know why we have LUBA.
Yes.
I really do mean that. You know, we're doing our best here, and
We think you've done a great job. We appreciate all the effort.
And so this is a time for questions. So are any more questions for the appellant at this time? Okay, I will now ask, thank you very much.
Thank you.
Gentlemen, for your presentation and answering our questions. And now I will ask the city, no, sorry, I'm just looking at my procedure here to make sure I'm doing all the right steps. This is now the point in time when the city presents the argument. And I will restate, the staff argument shall only rely on evidence in the record. And then at the end of the staff argument, I will ask the city council if any council members have any questions for staff, and those questions will be asked and answered, and then the appellant will have a chance for the 5-minute rebuttal. Thank you.
Mayor and City Council, Stephanie Davidson, Assistant City Attorney. I want to start by bringing us back to the big picture and how we got here. The city staff, the team working on this project, we started by doing a really expansive search for case law without a predetermined conclusion. We even asked applicant for legal authority to support their position at one point in time. So we've come at this truly with an open mind. Our position is also that if, we respect the law around non-conforming uses. If an applicant has a valid non-conforming use, we would support that. If there is a valid continuation of non-conforming use, we would support that. We frankly believe in the rule of law, and we think that the case law in this case, the many cases that we've cited, support the recommendation that staff have developed. I also want to point out that, non-conforming uses are exceedingly rare in Wilsonville. I believe this is the first time it's come up, but there is a, future impact of the decision you make today. This case, especially since the Class 1 is going to LUBA, this will presumably go to LUBA as well. Every future non-conforming use case that comes up in the city of Wilsonville, this case will be instructive in that other matter. So there's an impact to the decision you make today that's broader than just Home Depot. And so again, our recommendation is what we believe is the correct outcome when you apply those Oregon cases. Second, I just want to address the awkward elephant in the room. This is a strange case in a number of ways. I think when you look at the many cases we've looked at, what you typically see in non-conforming use cases, both like recognizing a non-conforming use, but also considering a continuation, you have something like a property owner who's been doing something on their property for a number of years, and this grandfathered right is something that says, if the city or county rezones and changes the law under that property owner, they should be able to continue doing what they were doing. So I think this is a right that's been developed in a slightly different context. But notwithstanding that, again, the city has found cases like Vance Baybrock, which has also been cited in the appellant's materials, that say that the identity of the user doesn't matter. We accept that and agree. It's not about the identity of the user, so let's proceed and evaluate the actual use of the property and the proposed use. It's also awkward because in a lot of continuing use cases, like, which one am I thinking of right now? It'll come to me later. I think the Fraley case is what I'm thinking of. In continuation of use cases, you have a property owner who's doing something that's slightly different than what was done on the property before. So you have some ability to gather testimony, evidence of what's actually happening on the property. I just want to acknowledge that it's a little strange that in this case we're talking about a proposed use that isn't yet happening on the property. So we have to evaluate the applicant's statements as to what may be done in the future. That's, I think, something that makes this a little bit awkward. And the third thing I want to acknowledge is, the relevant point in time, June of 2019, that was a number of years ago. 5 years? 5 years ago. The Fraley case is helpful too, because in that case, the original use that they were looking at, that use existed 20 years, I think, before the new continued use that they were trying to get protected. In that case, LUBA said very clearly, the fact that time has passed between now and, when that original use was recognized, that doesn't lessen the applicant's burden of proof. It doesn't lessen their obligation to put forth enough evidence of what happened 20 years ago in order to establish that continued use. So with that out of the way, before Miranda speaks, I do just want to remind everyone listening of the narrow issue before the council today, which is determined based on what they applied for in their initial application, and they applied for continuation of use. In our opinion, this is a three-part analysis. Number one, you start with what is the recognized nonconforming use, which was established in the City Council order on DRB Resolution 429. You then consider what was the existing use, and finally, you look at the proposed use, the Home Depot proposed use, and you say, are they the same or are they different? And I also want to emphasize that the city may draw distinctions. There's obviously a difference of opinion here, but I want to give council confidence. The Fraley case, so in the Fraley case, I believe the prior nonconforming use was the structural repair of RVs, motorhomes, things like that. The then current use that was occurring on the property was the repair of diesel engines. LUBA didn't say that all manufacturing or industrial uses are the same, and it didn't say that all repair uses are the same. It made a distinction between what was being repaired. So, again, based on city staff's review of applicable case law, the city may draw those distinctions. And before I pass it on to Miranda, I do just want to respond to a couple of things that have been raised today in the appellant's argument that are beyond the scope of what's before council today. Number one, the Class 1 decision. As you've alluded to, this is not a venue for relitigating that decision. Until that decision is reversed or remanded by LUBA, that is a decision of the city. And if you follow the appellant's suggestion and recognize a commercial retail use, you are ignoring that decision. And by the way, LUBA, when it reviews that decision, is not going to determine a new scope of nonconforming use. It will reverse and remand, and City Council will have to consider new evidence and, reconsider that question. I do also just want to respond to the references to the 1991 decision. Throughout this process, we have asked the appellant for, this is your position. What is the case law that supports your position that the 1991 decision is a controlling authority? They have never produced any case law to support that position. It's a bald statement. It's not supported by any case law. They haven't ever responded to our case law, like the Nahoda case, the Spurgeon case, the Sabin case. They've never responded on those cases. So it's a position that's totally unsupported by Oregon case law. I also want to point out that during the Class 1 proceeding, I can't remember, I'm pretty sure it was the City Council appeal where this was said, but appellant was asked for legal authority that supported their more broad position that you recognize, like a retail use rather than electronics related retail use. And they promised to provide that a month ago. They've had time and they haven't provided anything. So what that says to me is that there is no such case law out there. And finally, I think you all have been thinking about this already, but there are some things that are irrelevant to this decision. For example, the vision promoted by Barry Simmons, its alignment with the town center zone, that is totally irrelevant to this continuation of use that's before you. And I would just point out, at the DRB hearing, Barry Simmons made a statement that Home Depot would likely invest $20 million in the redevelopment of this area. And there were slides shown today of, other Home Depot locations that might serve as a model for what happens in Wilsonville. I think this really supports that this is not the appropriate path for this type of development vision. This is about continuing the use that existed in 2019. It's not about investing $20 million and making drastic changes to the infrastructure and to the area. So I have a couple other comments, but right now I will hand it to Miranda.
Thank you, Ms. Davidson. My name is Miranda Bateshell. I'm the planning director for the city of Wilsonville. Thank you, Mayor and Council. I am going to try to keep some of my comments slim as much as possible and cover what I think are the high and important points. Kind of reiterate a few of the things that have already been covered by staff, just to remind you really what the key issue is here tonight. As was mentioned earlier, this is atypical. I don't think a Class 2 decision has even ever been appealed to the City Council in the city of Wilsonville. And non-conforming uses are relatively recent in the history of Wilsonville. As a young city with young development, most of our development has been initiated on Greenfield, and we now have new zoning codes that have replaced older zoning codes and have created now this potential path for non-conforming uses. And so what I'm going to try to do is help make this clear for all of you tonight as much as possible of what I think are the key points in the record. But I'm happy to answer any questions you might have on things that I haven't covered that are in the development code or that might be related to the historic decisions on this property. So the key issue tonight really boils down to, are these two uses the same uses? The use that was on the property in 2019 when the city adopted the town center code, and it became effective on June 5th, 2019, which was the Fry's electronics related retailer. Is that the same as what Home Depot has proposed in the application that they submitted, which was deemed complete? And so even some of the materials that have come to light after that is not what we base the decision on. We do base the decision on what was in their application and what was deemed complete based on Oregon Revised Statute 227. So this gets to some of the points of Councilor Linville, your questions in terms of what was in the application itself. So I just want to kind of go over a few key facts in helping us determine what the DRB relied upon in making their determination, which will hopefully help you in making your determination this afternoon, which supports the position that this is not a continuation of a recognized non-conforming use. First, we have to look at what is the recognized existing non-conforming use? And you've been spending a lot of time talking about this, so I'm going to try to not spend as much time talking about it, because this was already affirmed in the DRB resolution number 429 that the council issued an order on, affirming that the legally established non-conforming use is the electronics related retail store. And to highlight that the use is not commercial retail or warehouse retail, which is what was in the application. Commercial retail is a classification of a lot of uses. So those who don't live in land use planning might not think about it that way, but those of us who do live in land use planning are well aware that commercial retail is far too broad of a category. I don't know of a single zoning code that would just offer commercial retail with no delineations, no bucket of uses, no determination around what that retail would look like. Like residential uses, you might say, oh, that's residentially zoned. Well, that could be single family detached, that could be middle housing, that could be a density of 10 dwelling units an acre, it could be a density of 50 dwelling units an acre and be calling for multifamily residential. Residential's the bucket. We have a lot of different uses underneath that bucket, that classification. Similarly, commercial retail operates in the same way. And even if we were to rely on the 1991 decision and what was in the code at that time, there were commercial retail buckets, and it was not just a broad commercial retail authorization under the 1991 decision or under Ordinance 55 in the code that existed at that time. So I just want to make that clear. So really tonight, determining the nature and extent of the existing non-conforming use, which is that electronics related retail over 159,400 square feet. What was there? We have to look at what was there and then determine what is that nature and extent, and is the nature and extent of what's being proposed the same? And so, as outlined in the legal standard for review that Ms. Davidson pointed out, local governments do have broad discretion to draw distinctions between the various uses, allowing some to continue but disallowing others. So up on the screen, you do have pictures from inside the Fry's retail store from 2019. And I'm going to talk a little bit about what was there at the time. I do want to highlight that the items that were for sale were electronics related. We had computers, monitors, small electronics, really the majority being small enough for customers to carry out of the store. As you can see here, laptops. Fry's did not operate in a warehouse format. There was a back stock and storage area, which, as you can see through these pictures, had very little inventory and didn't operate as a warehouse. And the display and the sales floor was oriented like a typical department store, much like a Best Buy would be oriented, or the electronics section of a Target, and not in a warehouse inventory format. No activities occurred outside of the structure at the location, including storage, staging of inventory, or receiving and unloading of heavy equipment. And I would just like to note that the appellant does not dispute this and also characterizes the use of the location at that time as an electronics retail Fry's with these activities and scope. And it is an undisputed fact that the use at the location in 2019 was not a home improvement store. And so next, we really have to understand what is the nature and extent of the proposed use. And this is the language that comes from the applicant's application. And it really describes what their operations are going to be, the types of products they're going to sell, but also who they're going to sell to and how that's going to operate. In reviewing applicant's evidence, it does include the images of a typical Home Depot interior, and I think we've already established on the record kind of what all of that merchandise can look like, so I won't reiterate it now. But much of it is displayed on floor-to-ceiling racking, which requires an industrial step stool to reach high display levels, and in appellant's own description is stored in a warehouse style. The appellant also states and clarified for you on the record tonight that the site plan includes an interior garden center and a lumber pad, and which is an operational area for safe receiving and unloading for their heavier merchandise, which requires large flatbed trucks to move and unload this heavy equipment outside of the existing structure. They propose to sell bulky products, including lumber, siding, windows and doors, large appliances like refrigerators, which cannot be moved by a shopping cart or even a box delivery truck, but transported by flatbed trucks. They also propose transportation and equipment rentals on site, which would occur outside of the building. On June 5th, 2019, which is the date which is important here, these uses were not occurring at this location. Thus, Home Depot proposes uses that are outside of the nature and extent of the protected existing non-conforming use that's been established. For a use to be deemed a continuation, it must have the same nature and extent as the recognized use, non-conforming use. And adding uses that were not there when the new code was adopted, even if they're within the same land use category, is seen as a change of use by the established legal standard in Oregon as described by Ms. Davidson. Adding uses is a change in nature and extent and thus not a continuation of the existing use. Appellant admits to being a home improvement warehouse store and not an electronics retail store. They sell substantially different types of retail products in a different format, including construction products, tools, and large household appliances. Appellant also admits to adding uses, including but not limited to a garden center, lumber pad, transportation and equipment rentals, services, and sales to contractors. This is not just different product, but different operational use. Appellant admits to adding operational activities and uses that are outside of the existing building, which is also a change from what was occurring in 2019. The as-built floor plan that was submitted by the current occupant to the city's building division in 2014, which can be found in the record, your attachment 3B, page 15, does show that the only similar types of products is small appliances, which are not the same as large household appliances such as washing and drying machines. And while that's not from 2019, the photos that we do have from Fry's in 2019 demonstrate consistency with that 2014 floor plan. I would just also like to note that the appellant spent quite a bit of time this evening talking about a hypothetical development that was not a part of their application, rather than spending time talking about more evidence showing that these uses were the same and that these uses were actually occurring in 2019. And I think it's important to reiterate, I know Ms. Davidson mentioned it, but it's important to reiterate that Mr. Simmons suggested that the proposed occupant would probably invest about $20 million into redeveloping the location, including upgrading roads, the water system, sewer system, and called the project a redevelopment. You can find this in attachment 5 on page 14 of the record. This statement to me strongly suggests more than putting in new racking systems in an existing building or doing simple maintenance. This suggests that the proposed occupant's plans involve significant changes to the location, which go far beyond a mere continuation of non-conforming use. There are substantial differences that the appellant has described in the record that distinguish these two uses from one another and amount to a fundamental change in the nature of the use, which is that legal standard we're referring back to. Not just in the retail products themselves, but also in the interior retail sales format, business operations outside of the building, and rental and service activities. The products and services sold by the proposed occupant are substantially different than those sold by the current occupant in nature, use, scale, and deployment to the end user. In other words, the proposed occupant's proposed use of the location goes far beyond a mere continuation of the non-conforming use of the location that was recognized by the Development Review Board and affirmed by the council. The rest of my comments will be much briefer, but I want to address a few other things that were put into the record. I just want to note that the appellant had noted that city staff denied requests to meet with them before April 8th, 2024. As the council is aware, the city prides itself on customer service, and it is one of our core values. My staff and I have met with representatives from Home Depot multiple times over the past 4 years. I found at least 6 meetings on my calendar with Dan Zoldak or Randy Fry regarding the Home Depot prior to April 8th, and initially meeting with Mr. Zoldak on May 14th of 2020. His team also held a pre-app with the city on March 24th, 2022. And I want to note that there's no evidence of staff animosity to the project or to the applicant team. Those comments are irrelevant and used to detract from the real question that we're trying to determine this evening or afternoon, whatever time of day it is. I'd also like to note that the city did not take a position that there was only one path forward for Home Depot, and I think you heard some of this on the record today about the choice that the applicant team made, but we consistently told them that there were 4 different paths available to them. They could find a location where zoning matches how they want to operate their store. They could apply for a change of use under the non-conforming standards. They could propose a development application that does meet the town center clear and objective standards for development, or they could propose a development application that requests waivers for height and square footage footprint of retail and meets the other clear and objective standards of development in town center. As mentioned by the appellant, they actually chose this process to go through the continuation of non-conforming use, and they also chose the bifurcated process after staff provided them an opportunity of 3 different paths forward in terms of responding to their initial Class 1 application request. There was a short deadline, as mentioned by the appellant. That was because we had to issue a response on the completeness for their application per Oregon land use law. So we only have 30 days to review completeness completeness. During that review of completeness, we recognized that they were asking more than just a Class 1 question, which is why we provided them with different opportunities to move forward. Cindy did a great job on highlighting the procedural background there and kind of what fell within the Class 1 versus what is a Class 2. I think you're well aware of that, so I'm not going to go into too much detail. I just want to say that because there's inherent judgment that is needed here to weigh the evidence of what is the existing recognized use versus what is the proposed occupant, you need to present and evaluate findings in doing so, which therefore indicates there needs to be a written interpretation, which is processed as a Class 2 as set aside in 4.030.01B3 of our code. So all this to say that so far the application has been processed correctly. We've evaluated it correctly as outlined in the staff report, and this evening we aren't actually evaluating the merits of the Home Depot or the Home Depot coming to Wilsonville, because what the appellant has applied for is just the continuation of a non-conforming use. And so we have evaluated it against those provisions of our code. We reviewed and presented the legal standard for evaluation of continuation of non-conforming uses outlined in the relevant case law in the staff report. And we have even explored the applicant's arguments to confirm our analysis and recommendations. And so I just want to quickly go over this table that staff have put together to try to help you in evaluating this decision. And looking through, there's a lot of information that's been put in front of you in the packet and here in person. This table hopefully highlights what is relevant to and within the scope of the Class 2 decision versus evidence that might be falling outside of that decision. Staff have found the following evidence informative and persuasive to our recommendation and the DRB decision in the middle column, which says the Class 2, because that's the process that we're reviewing today and the decision made today. And that is the site plan and narrative from the application, the photographs of Home Depot and testimony from the appellant, and the as-built floor plan and photographs of Rise from 2019. The appellant also provided the following information, evidence in the record that staff and the DRB considered but did not find persuasive or relevant to the application type under review. The first would be the references to the current town center zoning. The town center zoning is only relevant to determining non-conforming status. Appellant's argument of how current zoning regulations are applied to determining nature and extent of a recognized nonconforming use and thus continuation determinations does not actually follow law or Oregon revised statutes. Therefore, city does not find it persuasive. The Home Depot has not submitted a development application for review against the town center zone standards, and so therefore that zoning is not related outside of just determining it as nonconforming. Also, the appellant's traffic and parking analyses, these are more indicative of and relevant to a change of use application and does not actually support a finding of continuation of use. It indicates that there would actually be a change on the site. The possible developments presented in the appellant's PowerPoint, including addition of multifamily residential and other Home Depot redevelopment projects, is not the same as what was in their application and cannot be considered per ORS 227.178. The CC&Rs that have been presented, those are private agreements between property owners and have no bearing on city land use regulations and thus are irrelevant and not persuasive. As well as the certificates of occupancy, references to the International Building Code and permits that are issued to other properties. Those are irrelevant to land use decisions of any kind and are not relevant to this decision here. Building CFOs are issued at the end of a project being built. They're about the building safety and whether it's built to structural standards, and they're not part of Land Use Review Chapter 4 or ORS, which governs land use planning in the state. And finally, the 1991 decision and the application of ordinance number 55, which adopted development code overlay use areas for the city center district. Those are irrelevant to making nonconforming use decisions in the state of Oregon. Even if they were, though, we would result in the same determination. Ordinance 55 specifically called out different use buckets. So not all retail was considered the same. Even in the example by the appellant tonight about fast food, those buckets had both fast food and food and sundries. And so you could actually have a deli who couldn't go into a fast food building. They would have to go into an area that was zoned for food and sundries. So there were distinctions that were drawn very narrowly within that and codified into city code. And so in this case, uses of lumber or home improvement were not found within the central commercial overlay, which is what's overlaid onto this site, but would be found in other buckets of the original city center district plan and ordinance 55. Only the planning commission could review and say something was similar enough to allow a use from one bucket to the other. It was only done through a change of use and was not allowed by right. If council has any questions on these items, we would be happy to answer any questions. I do know that this meeting is running long, though. And so that concludes my comments. I just want to restate the focus, which really just comes back simply to, are these two things the same? And it's not just about product type, which I think the appellant wants to lead you to believe. The record shows that there's different customers, there are different products, there's also different operations, and all of that makes it a different land use. So with that, I'll hand it back to Ms. Davidson.
Yeah, just one more thought that I should have mentioned earlier. The city of Larson v. City of Warrenton case, I mean, that sort of supports the point Miranda was just making, that recognized nonconforming use specifically referred to trucks, cranes, other earth-moving equipment used in marine and land construction. So that's more support for that position. And I just want to end by emphasizing that Venn diagram that was on the screen earlier, which is basically an illustration of the Hengen case. We agree, like Home Depot's presentation by and large focused on that middle oval, the commonalities, what Home Depot and Fry's have in common. We accept that there are commonalities between those two uses. What the Hengen case says is, you have to focus on the differences. And so whereas Home Depot is focused on the commonalities, we have focused on finding the differences. So that's a big difference. But what the Hengen case says is the differences matter. That's it.
Thank you. Counselors, do you have questions? And before we go to questions, I would like to ask for a motion for a 5-minute recess. We have been sitting here since 11:30, some of us. Break. May I have a motion?
Yes, Mayor, I would like to make a motion for a 5-minute recess of council.
I'll second that.
It's been seconded. All in favor, say aye.
Aye.
And I will just note that, council, you're not allowed to talk about this during the break, and so also for the community members, please don't approach the council
And I
during
would
the break.
like to suggest that the counselors are able to go to different parts of the building. I'm going to go to the planning department. Someone else can go upstairs, so there's no chance they will be in the same room. Thank you for reminding us. We will reconvene at 2:35. And we will now go to our questions.
Yeah, I was going to say, Mayor, we are, if you have,
rebuttal.
well, no, if you have questions for staff, since staff did just
Yes,
present
we
argument,
did
you
have
can.
questions for staff that we didn't get to do yet.
Yes.
So, sorry.
And then you can go to the rebuttal.
That's another step that we need to have. Thank you. Okay, so for this step, counselors, we have the opportunity to ask questions of staff. Does anyone have a question? Counselor Linville.
Thank you. I'm recalling the two options that the appellant gave us for relief, and one of those options was to modify the Class 1 use decision at this meeting, and I would like a procedural, you okay? Legal opinion on whether that is in fact a possibility at this meeting.
Thank you, Councilor Linville. Amanda Guile, Hinman City Attorney. I'll actually take that. So I believe if I got the reference written down correctly from the appellant, was section 4.022 subsection 08 of our code, and 4.022 is the general appeal and call-up procedures for both DRB and City Council. And .08 is talking about the review body decision, and it says, I just want to read it. It says, upon review, the referee, commission, or board may by resolution, or the council shall by order affirm, reverse, or modify in whole or part a determination or requirement of the decision that is under review. And then it gives some sub things you need to do under that. And my legal interpretation of that is when it's the decision under review. Right now, the decision that is under your review is DRB resolution number 432, not DRB resolution number 429, which is the Class 1 decision. So my review of this Wilsonville code provision is pretty clear to me that the only thing that council is reviewing right now is DRB resolution 432, not the Class 1.
So if we were to do that, we would have to give public notice and an agenda of specifically what we were considering at that meeting.
Frankly, I'm not even sure procedurally all the requirements that we would need to do, considering that decision now is before LUBA. I think there would be additional procedural steps that would need to be taken, definitely.
Okay, thank you. The other question that I had was just asking for a clarification on which seemed to go, and with all due respect to the appellant, who was trying, I think, to move our timeline along, but it had to do with some confusion that I had about whether the Class 1 application required that the Class 2 application be submitted at the same time, or in order for the Class 1 to be determined and evaluated, and what communication was actually presented to the appellant that might lead them to believe that the city was requiring those two applications to be submitted either simultaneously or in conjunction with each other.
Sure, I can take that. Councilor Linville, again, Miranda Bateshell, Planning Director with the City of Wilsonville. We initially received the Class 1 application back in October of last year. It wasn't until we began reading, so it looked like a Class 1 application. It was for a determination of the existing non-conforming use, which determinations of existing non-conforming use structures and site conditions is a Class 1 determination as outlined in our code. As we read through the entire application and trying to determine completeness, because as you know, in the state of Oregon, city land use is required to do completeness review within 30 days of receiving an application. So during those 30 days of reviewing it, we noticed that there was a secondary question and request embedded within their application materials, which was a question about a continuation of use based on a new occupant. And that became apparent to us that that goes beyond just determination of existing use, because it's not what's happening on the site now, but it's a proposed occupant coming in with a new proposed use. And the question then became elevated beyond a class 1 to a class 2. So we make that determination. We're actually very careful and easy to elevate things to a class 2, because essentially if it's not specifically written, then it's being omitted for a reason in the class 1, in the code anywhere, but specifically in that provision where it says what we can determine in a class 1. And so because it went beyond the class 2, or beyond the class 1 into class 2 territory, we communicated that to the applicant. We wanted to make sure that they understood we can't actually answer both of your questions within the same application. And here's why, because essentially, our code would elevate that question to a class 2. Class 2s provide for public notification. It provides for when the staff, the planning director makes a decision, that decision is shared publicly and with the council and the development review board. So if they want to call it up, they can. So it provides additional transparency and process and public notification. So we can't actually process them the same, because the class 1 doesn't do any of those things. A class 1 is only, the appellant is the only one who can, or applicant is the only one who can appeal, and there is no public notification. So it's a completely different process. We can't really put those together. And so we notified the applicant as soon as we knew that. And we essentially outlined in an email letting them know that because we've received, their class 1 was filed and paid for, it was considered filed, we had to do the completeness review in 30 days. So we were basically saying we need to know within the next, I think it was 5 or 6 days, whether or not you want to essentially withdraw this application and just move forward with a class 2 continuation of use, or whether you want to just move forward with this class 1 and we're only going to answer what we're allowed to answer under the code for a class 1. Or, if you should choose, you could file essentially 2 applications, one to answer the class 1 question and then one to answer the class 2 continuation of use question.
Do you want this email?
Yeah, sure.
And this is some of the many pages that was given to the council in our public packets.
It looks like it's PDF page 92 of 500. And so this email was emailed to the applicant to say, essentially lay those things out and say, if you have questions, give us a call. And we never heard from the applicant until we received a class 2 application on December 15th. And so because the class 1 was never withdrawn and we didn't have any communication that they might want to do that, we are obligated under state law to continue to process their class 1 and make a determination of completeness, and it was deemed complete. So then we had to move forward with making a decision within 120 days, which is required by Oregon revised statutes. And so we moved forward with the class 1, and then it was the applicant's choice. They didn't wait to move through the class 1 process fully before submitting their class 2 application. That is their choice. They chose to apply on December 15th, and so staff have processed the class 2 in accordance with the same the process that's laid out for a class 2, which is also bound by the 30-day completeness review and the 120-day decision. I don't know if either Ms. Geil-Hinman or Ms. Davison would like to speak to kind of after the first DRB hearing, any discussion about combining them or not. But that was the initial timeline.
Yeah, I'm mostly concerned about where those applications came in. And then my question is, at what point, I think the only other one I have, is is there an opportunity for any applicant to withdraw an application prior to the public hearing?
Yes.
And so what is that timeline? I mean, in this particular case, the public hearing on the Class 2 application was April 24th, 2024, correct? April 23rd?
April
23rd?
April 24th, 2024.
24th? 2024. So it's possible that the applicant could have withdrawn, if they chose to, before that public hearing that evening, if they chose to do that. That is an option that any applicant has, to withdraw an application, correct?
Correct. So it's before a decision is made.
Yes. Correct. Okay.
If I may, I just want to add in that initial email in late November, where Cindy Luxhoy provided those different options when it was determined the Class 2 was necessary. One of those options was withdraw the Class 1 and we'll deal with everything in the Class 2. I also remember, I don't have the exact date, but there was an effort in January, I believe, to reach out to the applicant when we realized that it created a lot of confusion at the DRB to have this part of this decision over here and the other part over here. It was asked by the DRB, why can't we withdraw the Class 1 and combine everything? So there was an effort at the DRB level before a decision was made to reach out to the applicant and propose this so that everything could be handled at the same time. And they declined that. I think staff met on a Friday afternoon for several hours, came up with a proposed document that everyone could agree to that made clear that the Class 1 issues, if the Class 1 was withdrawn, that those issues would not be, conceded in any way, that those would be preserved for the Class 2. And they've declined that at every opportunity. So that's part of the story here with why we have a Class 1 and a Class 2 simultaneously.
So what I'm trying to get at is kind of just understanding, the city council made a decision on the Class 1 appeal on April 7th.
April 15th.
Oh, April 15th, that's right. April 15th, 2024.
Yeah.
And the decision or the hearing on the Class 2 application was on April 24th, 2024, which was a...
Well, I should correct, because I want to make sure it's clear. I think the initial hearing by the you're talking about the DRB here?
No, I'm talking about the council's question on appeal was done on April
15th.
April 15th.
Correct.
So, and the appellant was notified of the city council's decision. I mean, they were present at that hearing, but,
yeah.
And it's possible that should they have really wanted to wait until LUBA had acted on that appeal, they could have withdrawn the Class 2 application and waited for that decision on appeal.
Correct. The DRB had not made a decision yet on the Class 2. I think that was April 24th, 2024.
Okay.
So it was after.
Okay. Because it sounded, okay, that's fine.
But that is also the applicant's prerogative.
Absolutely, I understand that. I just wanted to know what was permissible. Thank you.
Okay, so I thank you. Councilor Berry.
Well, there's been a lot of information exchanged today, and I thank you for everybody for their time. And I think that, one of the comments or the intentions is that Home Depot is welcome to Wilsonville, at the right location and the right zoning and the codes. I was hoping that staff would summarize again, because I think the point of the hearing or today is this a continuation of non-conformance? And so can you again give us the information how this proposed use extends beyond the actual use as of June 19th, 2019 in terms of scope, nature, and extent, please?
Sure. So In 2019, when the town center zone became effective, Fry's was located in the building. The images that we looked at during, that are in the record in the packet are consistent with the 2014 floor plan. You can see that there was fairly low stock. It was not a warehouse retail use. I was operating like a typical electronics department store. Pretty small retail products that were being provided for retail users coming in and using the building and leaving. The new occupant, or the proposed occupant, I should say, the Home Depot is proposing a home improvement retail store, providing substantially different product. And I would note that it's not just like the type of product, but it's the nature and the scope and the size of that product, how it needs to get transported to the building and how it leaves the building. The vast amount of inventory that would be stored there on floor to ceiling shelving. The fact that there would be a lumber pad that would need to be added and dock doors removed. Those dock doors are used to back a truck up to and unload inventory straight into a building. A lumber pad is essentially there to unload the heavy equipment that can't be delivered in that manner, would be delivered outside, would be essentially staged there until it could be either moved in or moved off-site by whoever's coming to use that equipment. There are other services like the rental of equipment and the rental of vehicles that would also occur outside and are services that were not there in 2019, as well as the indoor garden center, which, as astutely noted by Council President Ackerval, could require an irrigation system that needs to be added to the structure that isn't there today and wasn't there in 2019. So those are, I think, some fundamental differences in my mind about how the product, it's not just kind of whether it's something that you can hold in your hand, but they happen to be different things, but they are substantially different in terms of the nature of those products, the scale of those products. You're not coming in to buy a laptop. You're coming in potentially to buy siding for your entire house, with a bunch of windows and a bunch of doors that have to be delivered to the store and back to a customer with much larger trucks and much more deliveries than existed in 2019. So we're looking at a change in operations, a change in the deployment to the end user, and not just products.
Thank you. Thank you.
Council President Ackerval? Oh, Councilor Dunwell, you want to go? Okay.
Miranda, I just have a question for you, just to refresh my memory since there have been a lot of conversations. Is the applicant Lars Larson in
Yes.
both? So
It's Lars Anderson.
Lars Anderson.
Oh, thanks.
Thank you. Lars. Sorry. Lars Anderson. It's a big difference. So just a question. I noted earlier in some research that Home Depot owns 85% of their locations, and this is just more of a hypothetical question. Lars Anderson is the applicant and the appellant. If we were to approve a continuing use and overturn the decision of the DRB, because Lars Anderson is the applicant, and is there anything in the application with the intent that this real estate is to be sold to Home Depot? And that may be outside of the scope of what we're discussing, but I'm just trying to clarify in my own mind if potentially LUBA were to come back and say, yes, the 1991 very large bucket of retail holds. And if we were to approve a continuing use in this class 2, because this is also convoluted at this point, and negotiations, whatever they may be, between Home Depot and Lars Anderson were to break down, and someone else were to come in, and as so many people chuckled in one of the meetings, Stephanie, when you said it could be an adult entertainment store, would we then be held understanding that it's not Home Depot that's the applicant and the appellant, but Lars Anderson. Because it seems like this conversation continues to go to Home Depot, but they're not the applicant, and they're not the appellant. And it at least to me, feels like it gives us a very unclear answer of what, and adds another level of gravity to whatever decision we may make, because there's all this conversation about Home Depot. But in fact, the conversation should really be about Lars Anderson and the owner, and secondarily, whoever that whoever is looking to occupy that location. Am I off base on thinking through that? Because it does create this really confusing conversation and scenario that things could go sideways.
Thank you, Councilor Dunwell. So I'm going to start, and then I will hand it over to Ms. Davidson. And I will invite, if I say anything wrong, because I haven't read the application as many times or in as much detail as Ms. Luxhoy, staff, I would invite her to come up and correct me if I do say anything wrong in terms of what's in the application itself. But the application is Lars Anderson, but it's on behalf of the Home Depot. And what is specifically outlined in that application is for the proposed occupant being Home Depot as the end user. And so that's how we have to evaluate the application. We often aren't evaluating things based on the owner or the potential transaction of land, because it could be based on the most recent time I have looked at records. The owner is still Lumberjack LLC, I believe is their official name, which is associated with the Fry's Corporation, and is not Lars Anderson or the Home Depot. But they could lease the location to the end user that could be the Home Depot. And so we're often not looking in terms of land use review itself, kind of that relationship of who owns or who leases, as much as if we have the property owner's signature essentially indicating that this applicant can apply for this use on that property, that's essentially the approval that we need to say that the owner's in the loop, and then we don't have somebody just trying to propose to do something on somebody else's land without their approval. But with that approval, it indicates to us that there's some relationship there, that either it will eventually be sold or they're going to be leasing it from that property owner or something, but that is all in place. What we're really looking at from a land use review standpoint is just, is it allowable based on the legal code that we operate within at the city and the state level?
That's really helpful. And I think that's a clarification that is really critical for us as we think through this, to understand what the true scope is, because you've got Lumberjack, Lars Anderson, and Home Depot all sort of being meshed together. And if I were to look at this from as an outsider for the very first time, I would walk away more scratching my head than really having an understanding of who we're really talking about. Thank you.
If I may also, Councilor Dunwell, again, Amanda Guile Hinman, City Attorney, I think the point that Stephanie was making in that prior proceeding is is talking about non-conforming use as something as broad as commercial retail. We rely on our past precedent to decide how we do things in the future. And there's more sites than just the Fry's location in town center that are now non-conforming. And this decision, like Stephanie said, will guide that future discussion. And so we do need to be mindful about what that means. Is if we say something is, if we say that commercial retail is the non-conforming use, that is a very broad scope, which is inconsistent with Oregon law about non-conforming use and how you evaluate it, which could have a ripple effect.
Thank you very much for saying that, because I think that really gets to the essence of the matter and the gravitas of the decisions that are being made, because it isn't just about a single company. It is about really having the decisions made now may very well set the precedent for future and also potential case law. So thank you.
Council President Aukerball. Oh, I just turned yours off. Did you click it? Go ahead. Oh, you are? Oh, Okay, I have these lights that show up here. I'm trying to look who's asking questions. So I have a question. I'm going to take a little different direction here, and that is, can you go back to, in our staff report and in some of the, I don't know, 1,500 or 2,000 pages of materials that we've seen here, there's discussion of the non-conforming structure and of the non-conforming use. This is all part of this analysis. And I just wanted to just ask you to just quickly clarify the difference here. So am I correct in saying that as of 2019, June 5th, 2019, that size of building was recognized as non-conforming structure, right?
Yes, Mayor, I can go ahead and take that one.
Yeah,
Again,
just take it on. Okay.
Again, my name is Miranda Bateshell, Planning Director for the City of Wilsonville. So in the Class 1 decision, the determination that was made was that there is an existing non-conforming use, an existing non-conforming structure, and existing non-conforming site conditions, and that's all non-conformance with the new Town Center Code that was adopted and became effective June 5th, 2019. So all three of those kind of buckets of things became non-conforming and were established in the Class 1 decision. I would note that the only appeal item that you heard and affirmed through your order was about the use. Okay. The non-conforming structure and the non-conforming site conditions were not appealed by the appellant. And so those are established and on the record. And I think that hopefully that answers your question. I don't know if you have follow-up.
That does get to answer what I think I was trying to get to, and I didn't say it very well, because I think there was a reference earlier today by the applicant, the appellant, about the structure. And what we're talking about today, again, and we are not just doing it for fun or what we like to talk about, to what I'm speaking for myself is that, you know, we're representing the city, and I always want to make sure that I find out what is the legal situation that we are addressing here, because being on the city council, I was talking to somebody about this before, a lot of different, you know, anybody can do it. You don't have to be a lawyer. You shouldn't have to be a water rate expert or any of these things. You come in here and what I do is I try to learn it, and you research and you find out, and I try to do my best to make sure that I'm not setting the city up, and in other words, our neighbors and residents for big problems, and doing the best for everyone. So with that in mind, I thought I heard, you know, when we hear discussion about the structure, that's true. You know, it became, as I understand it, became non-conforming in 2019, but it could have continued like that if Fry's still was there and wanted to keep occupying that building. That's just, they could continue in that. It was just described now in that manner, right?
Correct. But if there was a proposed occupant who wanted to modify that structure, then there would be a process of evaluation that the planning department would do to determine that modifications were not any more non-conforming. That is the standard that's in our code.
Okay.
And we have evaluated other properties in that same manner since the Town Center Code was adopted.
And there's a word that comes, so thank you. I think that gets it. There's a word that jumped out at me a lot from the beginning of this when we talked about it, and it kind of bothers me every time, but I realize the meaning and the use of it. And it's the word, but we use it differently in other parts of our social structure. And that is irrelevant. When I hear, well, that's irrelevant, it sounds really insulting. Like, well, I don't want to talk about that. I don't even care about that. But we're using that word in an entirely different way. And so in this structure, the way that I'm looking at that is we are, and help me with this, as the body sitting here on this appeal, there are certain things to consider and certain things that are not fair to consider. And it's not fair to the public, it's not fair to our neighbors, other businesses, anyone, there are certain things that are fair to consider and those that are not. And so that's kind of where we seem to use the term irrelevant. So a couple of those so I just wanted to state that it sounds kind of, it can get your hackles up thinking that it's irrelevant, but the way that I'm understanding it is not appropriate to consider it in answering the question that we are charged with answering. Is that right?
Correct, Mayor. I would say that, for example, information about a potential future redevelopment of the site and information about, adding multifamily residential, things of that nature, that wasn't in the application, and it isn't applicable to the application type that was applied for. And so from where I sit, that might be helpful information if I was making a different if the applicant was applying for a different type of development permit or land use application, and if they were going through that process, the information may be relevant. But you're correct, in terms of making a determination of continuation of use, it's not an application, so it's not relevant because we're not supposed to weigh it per ORS 227. But secondarily, it actually goes to a nature that would not be a continuation of non-conforming use. But it's not relevant to the application type that we're looking at.
And I would just add that we just mean it in the pure dictionary definition sense of that word, just meaning that it's not to the point, if you start from a place of looking at the case law to figure out what the correct analysis is, that evidence that we have considered is irrelevant is not properly considered in that analysis, or is not relevant to that analysis.
It's a legal term, so. No?
We just mean it in the pure dictionary definition sense of the word.
And so, thank you for that. Now, I wanted to go, no, that is a question for the appellant, I think. While I'm looking for my last questions, counselors, please think if there are any other questions that you have for staff. Because I think this is our last chance, right?
You can ask council if they have any further questions before you move to deliberation of either
Okay,
party.
so you have another, if something else comes up. Okay, so I think that's all of my questions then. Thank you.
Thank you.
And now we will hear the 5-minute rebuttal, which we all agreed to from the appellant.
Okay, thank you, Mayor Fitzgerald. And again, for the record, Keenan Orton McCallion with Schwabe on behalf of Home Depot. Covered a lot of ground in our presentation as well as staff's rebuttal there. So I'm going to keep my comments in my 5 minutes focused to the issues that are pertinent to the approval of our application, or I guess the appeal in this case. I think the rest of it has been addressed in all the application materials within the record. So I think first, I just wanted to respectfully disagree with staff's characterization of the impact of this decision having a broad impact across the town center area. Non-conforming use applications and analyses are inherently site-specific, so this one decision will not be controlling on your future decisions across the town center area. I think to inject that kind of broader importance into this analysis is frankly improper based on the approval criteria for the application as well as the appeal. Second, the Fraley case is not applicable to this proceeding. It dealt with the county non-conforming use analysis and the application of ORS 215-130. Staff actually conceded that in their staff report, yet it's been referenced probably more than any other case throughout this process. So again, we object to the reference to that case. It is not controlling on your decision and it should not be followed. Number three, the decision here, your decision and the DRB's decision was based on the standards and criteria. To demonstrate compliance with those standards and criteria, we've applied the substantial evidence standard. That includes all evidence in the record. The evidence is not limited just what was submitted by the applicant in their application on December 15th. The evidence submitted subsequent to that is also substantial evidence, and it is part of the record. And frankly, to try and base the decision on just the application materials that were submitted months before any of these appeal proceedings sets up a record objection issue for LUBA. So we object to that. In terms of statement of the use itself being commercial retail being too broad, the planning director made that statement. I disagree with her statements on that point. I actually don't think that's how land use works. Both the town center zone and the the PDC zoning for the property prior to the town center plan being adopted did not draw distinctions for retail uses. Staff explicitly acknowledged in their staff report materials that electronic stores was not an allowed use in the PDC zone. It was retail use. So to try and adopt a narrow interpretation of the use at issue here, again, I think is not in accordance with the zoning language in both the existing or the historic zoning, as well as non-conforming use law. I think next, the planning director's characterization of Home Depot's operations in terms of people coming to the site and buying siding and windows for their house was again inaccurate. Mr. Simmons talked about how Home Depot uses warehouse retail centers for their professionals and for folks that are picking up large orders. Those people don't come to a Home Depot store to buy materials to frame out and install windows on an entire house. So the impacts related to that are not relevant in terms of determining the continuation of use here. I think next in terms of relief, OAR 661100021 allows local jurisdiction to withdraw a decision currently on appeal from LUBA for reconsideration. So there is a very clear mechanism here for how the city council could address the incongruence between the Class 1 decision on appeal to LUBA and the Class 2 application that's currently on appeal before you right now. So there is an option for relief where we could take this back if you do feel like you've gained more information and developed a different perspective of the situation throughout these proceedings. Again, that is your prerogative, but there is a mechanism to do that. I think with that, I will rest and answer any questions you guys have, really. I mean, I appreciate your time. This has been a long one, and looking forward to any questions.
I have a question. Yes, I also noted that, from my observation, what I learned that if there's a professional builder who is building 35 homes and they want 350 windows or something, those are going to come from some distribution site. But so I understood that. But if somebody, but really there's a supply of windows and doors in the building and a person can go buy them. They're not all going to be, don't things move through the store somehow? I mean, if you're going to buy 3 doors with your pickup, isn't that part of how home, I mean, when I've used it for many years, don't you, 50% of the people, I just wanted to clarify that they're not all professional builders.
No, that's accurate. And I mean, I'll let Mr. Simmons speak to this as well, but Home Depot caters to the home professional, you and I, Mayor Fitzgerald, as well as a building industry professional, a contractor.
So how do, when I've gone to buy things for building fences and things, I go in there and pick it up.
Absolutely. And I mean, I'm not arguing that doesn't occur here. What I'm saying is the planning director's characterization that you would go to buy all of the materials to site out a house and install the windows is likely inaccurate. I mean,
I recognize that,
yeah.
Totally.
So on a rebuttal, that is why I raised the issue.
I hear you.
Yeah.
Okay. Okay, another question about the trucks that you can rent. I've been a customer that, and somebody wants to rent a pickup to either pick up their doors and windows or something. Could that be delivered? Do you order it online and you go pick it up here at this local location to make it convenient? How does that work?
Barry, are you online still?
I am.
I don't want to speak for Home Depot, of course, so go ahead.
Yeah, I can't I'm not allowed to turn my video back on for whatever reason.
We can hear you.
Okay, perfect. So the question is about rental equipment at this particular location. We have not specifically applied. Oh, here we go.
There you are.
We have several stores, many stores across the country that don't allow outdoor sales, outdoor rental equipment, et cetera. So it wouldn't be unusual for us to have a store that operates differently than, say, your prototypical store that staff went by and took pictures of. So in that case, if a customer showed up at the Wilsonville Home Depot looking to rent a truck, it may not be there. They may have to go to a neighboring store to get that particular piece. And we have several stores around the country that operate, in that sense, differently based off of the requirements of the jurisdiction.
Okay, so but it's possible that the vehicle rental would be a part of this location.
That's not, we're not intending that today.
Okay, thank you. I hear you.
Mayor Fitzgerald, to follow up, what Barry said is we are not proposing vehicle rental at this time. Were we to propose that in the future, that would require modification and subsequent process with the city.
Okay, thank you. Councilor Barry.
Yeah, I had questions about the windows too, but can you explain to me, like, percentage-wise, this building's 159,000. Is that your average Home Depot size? Or if not, what's the percentage that's larger and what's the percentage that's lesser? It's because you were talking about typical uses in the building, so I'm trying to envision what the differences are.
Thank you for the question. Dan or Barry, do you want to take that?
Sure. I think the typical Home Depot is 126,000 with an outdoor garden center of approximately another 26,000. And so on this particular store, all the operations will be inside the building. So we won't have our typical, plant materials that would be on a normal Home Depot. So we won't have the same product line, but we'll have some garden center facilities that will operate inside the building. And so, but this is a bigger footprint than we're building across the country.
Barry, I don't know if there's anything you wanted to add there.
No, I think Dan summed it up pretty well. Yeah, it's also, we would normally do a smaller footprint and a little different shape. So we're actually, our operations team has kind of gone out of their way to adjust to the existing structure here at this location.
Thank you for the question, Councilor Barry.
Okay, I'm not seeing any more questions. Is that right, Councilor? Sometimes I miss that. Well, thank you for your rebuttal. And that brings us to, we have now brought us to the point where this is the time for the council to deliberate on the appeal. Just checking with our parliamentarian. Have I got all the steps?
Yes, Mayor, I think maybe just one more, just double check that there's no questions for either the appellant or for staff before you all head into deliberations.
If I could just ask a procedural question. Do we close the public hearing prior to deliberations?
You're not in a public hearing.
Oh, okay. Never mind.
So, but I do appreciate your question because this is a very specific process, and I repeated some of these for myself and other people. And so the way this goes is we have now determined, I think, that everybody has asked all their questions. I'll probably ask you one more time because we have everyone here, and this is the time to get your questions answered. And
Counselor Linville, sorry, Mayor, and I think maybe what your question is going to and why I've instructed the mayor to ask just one more time if there's any other questions is if there's a motion that's made and seconded and you all get into deliberations, that's not a time for either staff or the appellant to be answering questions. That's for you all to deliberate. If you have questions specifically about the process you all are following, that's different, but about the substance of the matter really should be resolved before you all are in your deliberations.
What I'm really wondering, and maybe it's a question for the mayor, is if I'm going to make final remarks, I want to know when in the process I can make those final remarks, because I don't want to do it too early. I'd like to do it at the appropriate time.
So that's a great question. That's just what we're about to do. We are going to ask for a motion, and we're going to ask for a second to the motion. And then I say, is there any discussion? And that's when you would make your final remarks. So this is the point for clarifying questions for staff, I think, or the appellant.
Yeah, the applicant team is available if you have any more questions. Otherwise, we really appreciate your time. I know this is the second round, so thank you guys.
Okay, good question. All right, so sorry to keep asking this, but does anyone have any more questions? Okay. Hearing no further questions, I hereby, I'm going to, as is our standard protocol, I will ask Council President, which I often ask Council President to just keep it simple, for a motion, and I will ask for a second on that motion to adopt an order to either affirm, reverse, or modify the DRB decision just as a starting point. Once the motion is made and seconded, we will have a discussion. And making the motion or seconding it does not bind either motion maker to voting for that motion. It is simply, or the person who seconded it, is simply the mechanism for starting the discussion. So I would like to ask Council President if you'd like to make a motion.
Yeah, I'll make a motion on an order of appeal for the Development Review Board Resolution number 432. And I'll read the order to help provide some detail too. Whereas on December 15th, 2023, the city received an application for Class 2 review with respect to the real property located at 29400 Southwest Town Center Loop West, respectively the location, from applicant appellant Dan Zoldak of Lars Anderson and Associates, Inc., appellant. This application is referred to as AR23-0031 in city records. And whereas in its application, appellant requested a Class 2 staff interpretation to confirm that the Home Depot and Fry's Electronics are both warehouse retail uses at the location, and alternatively, a staff interpretation of the Wilsonville Development Code to confirm that the Home Depot store proposed for the location constitutes a warehouse retail use and may operate in the existing structure. And whereas the city processed the appellant's application as a request to confirm that the Home Depot's, the proposed occupant, proposed use of the location will constitute a continuation of the non-conforming use, as provided in Wilsonville Code WC Section 4.189.01, which existing non-conforming use was confirmed in the related but separate Class 1 decision relating to the location, which was established by the Development Review Board, DRB, and Resolution number 429, and later confirmed by order on appeal by City Council dated April 15th, 2024. And whereas the planning director referred the application to the DRB for a public hearing per WC 4.030.01B, and did not issue a planning director's decision. And whereas the DRB held a public hearing on April 8th, 2024, this proceeding is referred to as DB 24-0003 in city records. And whereas the DRB closed the public hearing on April 8th, 2024, but kept the written record open to allow the submission of evidence and legal argument, and reconvened to consider the application and issued a decision on April 24th, 2024. And whereas on April 24th, 2024, the DRB unanimously adopted resolution number 432. And whereas during the regularly scheduled meeting on May 6th, 2024, anticipating that that appellant would appeal resolution number 432, City Council adopted an order establishing the scope of this appeal proceeding and the procedure that City Council would follow during the appeal proceeding, and set May 17th, 2024 at 12 p.m. as the date and time of the appeal proceeding, the procedural order. And whereas on May 7th, 2024, appellant submitted the document titled Appellant's Notice of Appeal to the city, the Notice of Appeal, within the prescribed appeal period. And whereas City Council held an appeal proceeding to address this matter on May 17th, 2024, in accordance with this procedural order. And whereas all references to the staff report in this order are to the staff report prepared by staff for the May 17th, 2024, titled Order on Appeal, DRB Resolution Number 432, the staff report. And all citations in the following findings are to the attachments to the staff report. Findings. Number 1. The foregoing recitals are hereby incorporated as findings of the council, as if fully set forth herein. Number 2, as of the date of this order, the recognized non-conforming use at the location is a 159,400 square foot electronics-related retail store, which was determined by the DRB decision in case file DB 24-0002, resolution number 429, and affirmed by council in its order on appeal dated April 15th, 2024, the recognized non-conforming use. Council finds re-argument of the settled issue of the recognized non-conforming use in the Class 1 land use proceeding irrelevant to this decision. Number 3, appellant describes itself as a home improvement warehouse store, attachment 3B, page 89, which is not the same as an electronics-related retail store. Number 4, appellant has the burden of proof in this appeal to establish that the proposed occupant's proposed use of the location would be a continuation of the recognized non-conforming use at the location. Council finds that appellant has not satisfied its burden of proof for the following reasons. A, council finds that appellant relies on evidence irrelevant to this Class 2 review, including 1, the exhibits attached to the appellant's April 15th, 2024 open records submittal to the DRB, 2, discussion of the town center plan and related zoning, and 3, the document referred to as the 1991 decision. Throughout these proceedings, attachment 3B, pages 94 to 254. Council finds the reasoning on pages 14 to 17 of the staff report persuasive. B, proposed occupant proposes to engage in the following activities at the location, and there is no evidence in the record that establishes that the current occupant engaged in these activities at the location as of June 5th, 2019. Regardless of any ancillary commonalities that may be shared by the proposed occupant and current occupant, these activities amount to a fundamental change in the nature of use and go beyond the scope of the recognized non-conforming use. See Hengren versus Clackamas County, 115, or App 117, 121, 1992. The ancillary commonalities are insufficient to compel the council to grant the relief that has been requested by the appellant. Based on the document titled Applicant's Narrative and Exhibits Demonstrating Compliance with the Relevant Approval Criteria, which was submitted by the appellant to the DRB, proposed occupant plans to sell tools and construction products. Attachment 3B, page 89. The description is supported by photos showed during the appellant's presentation at the DRB public hearing on April 8th, 2024. Attachment 3B, pages 468 to 484, which showed images of merchandise often stocked floor to ceiling that included large electric power tools, floor polishers, tools, hardware, chainsaws, flooring, paint, cleaning products, windows and doors, large household appliances, for example, washing and drying machines, refrigerators, light fixtures and lighting systems, saw blades, and patio furniture. There's no evidence in the record of current occupants selling these products or even these types of products. Further, the as-built floor plan submitted by the current occupant to the city's building division in 2014, attachment 3B, page 15, supports this assessment. The only similar type of product shown on the floor plan is small appliances, which are not the same as large household appliances, such as washing and drying machines. The as-built floor plan predates the date of nonconformance by 5 years, which lessens the weight council assigns to this evidence. However, council finds it more credible than other evidence submitted by the appellant. That is, 1, not from the location, i.e. other Fry's electronic source, 2, earlier in time, and or 3, fails to demonstrate that the current occupant and the proposed occupant engaged in the same retail sales. 2, proposed occupant plans to have a garden center, i.e. a nursery that sells live plants. The site plan included in appellant's application materials shows a garden center at the front of the building. Attachment 3B, page 256. During the DRB public hearing on April 8th, 2024, Barry Simmons, a real estate manager for the proposed occupant, acknowledged that there would be a garden center with live goods inside the existing building. Attachment 5, page 10. A garden center that contains live plants would require some kind of irrigation or watering. There is no evidence in the record of current occupants selling these types of products or anything live that required irrigation or watering. 3, proposed occupant would have at least some operations outside of the existing building at the location. The site plan included in appellant's application materials shows a lumber pad at the back of the building, attachment 3B, page 256. The extent of the activities that would occur in this area is not clear. During the DRB public hearing on April 8th, 2024, Barry Simmons stated that the lumber pad area would be used to unload heavier products off a flatbed truck, and that it would not be used for exterior storage. Attachment 5, page 10. There is no evidence in the record of current occupant having any operations outside of the building that currently exists at the location, whether for receiving, unloading, temporary storage, or for some other purpose. Although the extent of these activities is unclear, council must rely to some extent on what has been represented in appellant's initial application materials. 4, contractors and other home improvement professionals would account for close to half of the proposed occupant's annual sales. Attachment 3B, page 90. There is no evidence in the record of current occupant selling to contractors or other home improvement professionals. C, During the DRB public hearing on April 8th, 2024, Barry Simmons suggested that proposed occupant would probably invest about $20 million into redeveloping the location, including upgrading roads, the water system, sewer system, and called the project a redevelopment, quote. Attachment 5, page 14. This statement strongly suggests that proposed occupants' plans involve significant changes to the location, which go far beyond a mere continuation of non-conforming use. Number 5, appellant failed to preserve any argument regarding the utilization of both Class 1 and Class 2 review process in this matter. Assuming without acknowledging that the argument was preserved, WC 4.030.01A.7 states that confirmation of an existing non-conforming use is subject to a Class 1 review, not the determination whether a proposed use is a continuation of an existing non-conforming use. A Class 2 review is required for determining continuation of existing non-conforming use, as explained in the staff report. Further, council finds that city staff proposed that appellant withdraw its Class 1 application while preserving its arguments concerning existing non-conforming use in order for the Class 1 and Class 2 applications to be processed together, and appellant refused. Attachment 3B, pages 63 to 65. Number 6, DRB followed correct procedurals, and in particular, the DRB did not err when it adopted the staff report dated April 1st, 2024, for the reasons stated on pages 2 to 3 of the staff report. DRB properly applied the relevant Wilsonville Code provisions, including but not limited to WC 4.030 and 4.189, as evidenced by findings A5 through A11 of DRB Resolution Number 432. Number 7. For the reasons provided in the staff report, council finds appellant's arguments unpersuasive regarding A, parking spaces and traffic impacts, B, certificates of occupancy, C, the 1991 decision, D, the 1992 CC&Rs, E, current town center zoning regulations, F, the codification rule and relatedly ordinance number 55, and G, the common nucleus test. It is therefore ordered by the City of Wilsonville City Council at its special meeting on the 17th day of May 2024 that the Development Review Board decision in resolution number 432 is affirmed. And further, that this was the correct and appropriate decision made based on applicable laws, policies, and standards. The appeal is therefore respectfully denied.
Thank you. We have heard the motion read by Council President Aukerball, and thank you. I hope you still have your voice, but I appreciate having all that detail to start with. I will ask for a second.
I'll second it.
The motion has been seconded by Councilor Berry. I will now ask the council for their comments, and may I start with Councilor Linville? I know you're ready.
I am ready. I want to thank the appellant for being here today and withstanding the length of this appeal proceeding, and the staff for answering our questions so that we can make a good decision in this matter. And without discrediting or disrespecting the expertise and integrity of any member of the City Council, I want to memorialize that we are each citizen volunteers. We represent the City of Wilsonville as elected officials, but I think, as the mayor said earlier, we're just citizens of this community, charged with some responsibilities. And although there may be some there may be some application of other alternatives to our motives. I believe that it is the city council, each member of the city council's intent to represent our citizens correctly and the integrity and care of our community. Although I have some personal opinions about whether or not there is a need or desire for Home Depot to be located in Wilsonville, that is not the question before the council today. The question before us relates specifically to the question on appeal, and that is the Home Depot use the same as the previous Fry's use at the time that I believe is not disputed when the decision of nonconforming use was determined. So the question is, is Home Depot eligible for a continuation of the nonconforming use applied originally to Fry's Electronics? And I hope our citizens understand that this is not a reflection of our hopes or desires for Home Depot in this community, or a reflection of even the use of the current property that is there, that is now not occupied but owned still by the Fry's. I know there are citizens who are concerned about the condition of that property and the hope for improvement in that area. So our responsibility as City Council is to review and determine this appeal based on the DRB decision and the entirety of the record. And I would like to say personally that I have reviewed the entire record, as well as the information presented on appeal today and in writing. And my decision in this matter is based on the as well as the previously deliberated and decided order that was done by the City Council on April 17th, 2024. So it is my opinion that non-conforming use decisions are critical, and while they may not be binding in the future on this council or any future council, that doesn't, in my opinion, make them any less important. And as case law, I think, and case reflection, they do have an impact on our community long-term. I think it is our duty as the City Council to protect the integrity and the code and the will of our citizens of our community, and particularly those that have put a considerable effort into the development of a vision for our town center in the future. And I agree with the content of the order. I do believe that the burden of proof in this matter was really on the appellant. And while I have reviewed all of the records and the presentations and our previous decision, I do not find a reason to deny or to grant the appeal on the DRB decision.
Thank you, Councilor Linville. Councilors, I don't see any lights here. Who would like to go next? Councilor Berry? Okay.
So I also agree with what you were saying, that as city council members, we're volunteers, and our mission was read at the beginning of today's meeting by our mayor. Thank you. And that I just really believe in the planning process and that towns get to determine their vision and their future, and that it's really important that citizens and business people, all the stakeholders, have a voice and that they're listened to by the Planning Commission, the Design Review Board, the City Council, staff, whatever. And we have a new plan, which I mentioned last time that we had this meeting, and that the focus is that the city has a new vision, and that when you have a non-conforming use, you have to look and see, does this really fit with the existing use? And it's my opinion that the Fry's business is really different than the Home Depot business, which is more of a retail warehouse with large products that are trucked in and out. 50% are contractors and 50% are residential users, whereas the Fry's use was small products that people hand carried out, and they were electronics. So as I mentioned earlier, I'm not opposed to Home Depot coming into our city. I think we really welcome it, but I really believe in comprehensive plans and zones and finding the right locations so that business can thrive. And I like seeing our businesses thrive. I like our residents feeling happy that they have the services and the goods that they want. But I just don't think that this is a good fit for non-conforming use. Thank you.
Thank you. Councilor Dunwell?
Thank you, Mayor. I really don't have any other comments other than what I've echoed the other councilors have said. This has been a convoluted process. There's no question about it. And to add to that is that, I'm just going to lay it on the table, and because we are a small town and rapidly growing, and there has been so much input into the vision of the future of this city by those that did not include myself. I feel that as a counselor, it's my responsibility to uphold that vision and all of the work that went into it. I also know that because we are in a time of emotion that can be expressed in social media, that it can become a much bigger issue and a much bigger conversation than what is in front of us today. And it is so important for all of us as counselors to continue to focus at what is at hand in front of us, and our decision today, despite our own opinions and despite our own perspectives on what we believe that the future of the town center plan should look like. We have a responsibility as elected officials to, as I said earlier, to support and uphold city code, ordinance, and plans that were put into place by our predecessors. And I still stand by that today, and I support everything that the DRB has put in place, and the decisions by our well-tenured and our extremely astute city planners and legal counsel. And I also would like to thank the applicant and appellants for their tenacity and their efforts on moving this to where we are today, because I know that this has been a lot of effort on your part too. But I continue to stand that this is a difficult decision, and I do support the position of the DRB and uphold it.
Thank you, Council President Akkerval.
Thank you, everyone, for hanging with us here for all this time. I understand we're looking at the continuation of use, but there's been so much discussion about the Class 1 decision today as well. I observe that the Class 1 decision is in the hands of LUBA. and I don't understand why we wouldn't allow LUBA to do their job. So I would like to allow LUBA to do their job. And so our current determination and definition that we have is, we all know the number now, it's 159,400 square foot electronics-related retail store. And the case law that was presented, the arguments that were presented, the materials that we've all reviewed, the, expansive materials that we've all reviewed, I think it supports that it's not a continuation of a 159,400 square foot electronics-related retail store. We've seen, there was quite a bit of conversation today about the products inside this building, and they both sell hats. But I think we see that there's a different set of systems around the operations, around the products, around the sales. And so for all of those, I'm not looking at the tangible thing, but the system that is bringing that to fruition. I do not see this as a continuation of the 159,400 square foot electronics-related retail store. And that has guided my decision.
Thank you. And I appreciate everyone's time who wants to see really great activity in our town center area and across our city. We have some great opportunities for development. I just want to reflect on how I know that's true and how I know that we will be a good site for more development in our city. We now have, I just checked, being a business-friendly community that pays attention to the businesses that are here today, the ones that can be here in the future, and those that people want. There's not, we know that we have a lot of opportunities in the future. Right now, the city of Wilsonville calculates its private sector payroll. That's all the paychecks that go out in the city across our city, excluding the Coffee Creek Correctional Institute in the city, excluding any public and, school payroll. Just the private sector payroll is now $1.2 billion. And that increased, as I calculated it with our finance director, about 38% in the last 10 years. And I hope we keep going in that direction. I think that's a great direction. And I also think that I've shopped a lot at Home Depot and done all those kinds of projects for many years. So if it were a choice of that, if that was what people were asking us today, we would have that is not what the question is. The question is stated very clearly in our materials, and that is, do we agree with the DRB decision that the continuing use, does the use of Home Depot comport with, and does it line up with what I personally have determined through the best of my ability, looking at all of the material I've been given, is that an 159,400 square foot electronics related retail store? My determination is no. I cannot in good conscience say that is. So the cities, I made some notes on things that were in the staff report just to wrap this up, because these are hard decisions, and it's easy for somebody to misconstrue it in social media, and that still may happen. But here's some other things that are always should be in front of us when we make these decisions. And I said this before briefly, but I'll say it again, that the city's determinations at every level in both the Class 1 and Class 2 proceedings have been based on the Wilsonville Code, Oregon law, and Oregon case law. I believe that. Neither applicants nor cities in any situation that we do should get to pick and choose or apply some current code criteria applicable at the time of the application while also applying regulations from obsolete code language or just a willy-nilly approach. I think if anybody thinks about that, if it happened next door to us in some situation, we would be really alarmed if we didn't know that there was something that could be predictable and transparent to our community on how we're making decisions. So it should not be just to pick and choose, what do we want to do today? If the appellant wants a determination based on a commercial retail use using the standards in the town center zone, then I believe the applicant, as we've heard it mentioned a few times here, any applicant has the opportunity to approach this in another way, which is submitting the appropriate development application, and to say that wouldn't work, I don't know, I don't think that's, we don't know that that wouldn't work. I don't think it's been, we did not get that application. And so, as I said earlier, this is clearly an example of why LUBA is necessary, because the applicant, in all good faith, has a different view. That I understand that. They don't agree with this, with what I'm saying. And that's where LUBA comes in. So LUBA and the Oregon appellate courts have clearly established the standards that apply to non-conforming use cases over the course of decades. And I believe that, you know, the way that I want to operate here is to follow the rules of law, and therefore my decision is also going to be to uphold the DRB decision. So I think we've all made our comments. I will call for a vote. And I'll ask the city recorder for a roll call vote.
Counselor Berry?
So can you just phrase it so?
You're going to answer aye if you are agreeing with the motion.
To deny the applicant?
No, the order. Whether you approve of the order.
To uphold the DRB.
Oh, yes, aye.
Counselor Linville?
Aye.
Council President Akkerval?
Aye.
Counselor Dunwell?
Aye.
Mayor Fitzgerald?
Aye. The motion passes 5-0. If you desire to appeal this decision to the Land Use Board of Appeals, you must make application stating the grounds of the appeal in the form and within the time prescribed by law. Thank you. Meeting is adjourned.